Good morning, everybody. Happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on our 3-hour journey through Courtlandia this morning. It is a slow start out there in Courtlandia, but we do have Magistrate Chisholm, so we will start there.
Hansen. So we can get started a half a minute early. That's good. There we go. This is 26RO03159. Ms. Hansen, you were cited for failing to yield back on the 11th of May at about 8:06 in the evening. The incident occurred in the area of 11 Mile and Center Streets in Royal Oak. You can admit responsibility for failing to yield. You can deny responsibility for that, or you can admit responsibility with an explanation. How do you wish to proceed?
I'll admit with explanation.
And that explanation is what, please?
Well, I guess it was human error, and I was trying to turn and realized I couldn't turn, and it was and I just didn't see. So human error.
Your Honor, if I may, I'd like
Please.
to amend the citation to impeding traffic.
Impeding does not carry Secretary of State points, ma'am. And that's the reason for the officer's amendment.
I thank you for that.
Mm-hmm.
And there was a crash.
Correct.
Yeah.
And nobody got hurt.
No.
just her, yeah.
The fine on impeding with a crash is $220. That can be paid online. You can mail in a check, or you can, if you prefer, you can drop by the courthouse and pay it at the counter, whatever works for you.
Okay.
I think most people pay it online, so that seems to work out.
Okay. Do I need to determine that now?
No,
Okay.
you got plenty of time to think about it. If you want to pay it online, the website is called allpaid.com, ALLPAID.com. And the court's number is 3031-3031.
Okay.
And I saved you about 212 keystrokes. Find it. So, okay.
Thank you very much, Magistrate, and I thank you, Officer, for coming.
Yes, ma'am.
And you're all set. Thank you.
Thank you both. Have a good day.
You
As
too.
well.
Down there.
Got Mr. Raymond's Integer Clayton. Who's the Motorola Razor 40 Ultra?
All right, good morning once again, everybody. It is TCF Live on a Wednesday. Welcome to all of you. Do say good morning in the chat if you haven't already. Looks like Magistrate's still trying to get his stuff together, but we have other options now that have popped up. Let's go say good morning to Judge Hunter. Looks like he's in Kalkaska this morning.
Your attorney was proposing a potential agreement that would not bind the court, but which would be a sentencing agreement. And what I indicated is I needed more information. There was much more said than that, but that was the sum and substance. Since that time, counsel, I received a joint memorandum in support of a sentencing agreement. I've had a chance to review that. And I want to thank the attorneys. That type of memorandum is extremely helpful to me. I know a lot more about the alleged facts of the case, and it helps me to determine whether or not I would be able to support a sentencing recommendation that the attorneys have reached. So I've had a total chance to review that. Again, that was a very detailed background of the factual circumstances, the legal arguments, the reasons for the plea agreement, and everything else that this court would need. So I'm appreciative of that amount of detail. And with that detail, I don't have any issue agreeing to, at this juncture, the sentencing recommendation between the attorneys, which was that there would be an in-guideline sentence. Mr. Sizemore, has your attorney gone over that circumstance with you?
Yes, he has.
And do you understand what the plea agreement is and what the sentencing recommendation is?
Yes, I believe I do.
All right, we'll make sure and I'll go over it in detail with you. But counsel, in response to the court's statements, did you have anything further you wanted to state for the record outside of the sentencing recommendation memorandum?
No, I don't, Your Honor.
Mr. Germer?
And neither do I, Judge.
And I know it's in the sentencing agreement recommendation and memorandum, but can you state for the record the terms of the plea agreement then?
Your Honor, the agreement would be, defendant would be pleading to count 2 as a habitual third offender. There would be an agreement, a sentencing agreement, to a sentence within the guidelines range, whatever those guidelines are calculated to be. Defense counsel and I have some estimate of what those guidelines are, but obviously, whatever the guidelines range is scored by the court, the only agreement is that the ultimate sentence will fall within those guidelines.
And then if I was to deny the sentence within the guidelines, I would give the defendant the opportunity to withdraw his plea.
Correct, Your Honor.
Is that all accurate, Mr. Germurthy?
That is all accurate, Judge.
Mr. Sizemore, did you hear those terms?
Yes.
You understand those terms?
Yeah, and I'm in agreement with them.
All right. Is that what you want to do then, is plead guilty under those terms?
Yes, I do.
Raise your right hand, please. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Mr. Sizemore, under this plea agreement, you're going to be pleading guilty to what's called count 2, controlled substance delivery or manufacture of less than 50 grams containing the mixture containing the controlled substance fentanyl. You understand that?
Yes, I do.
Really, that's a felony offense with a maximum statutory penalty of up to 20 years in the state prison system and or a fine of up to $25,000. And a consecutive sentence could be imposed for any other felony conviction. Are you aware of that?
Yes, I am.
You're going to be pleading guilty as a habitual offender third offense notice. And what that means is the statutory maximum is doubled. So as a habitual third offender notice, count 2 is punishable by up to 40 years maximum and a fine or a fine of up to $25,000. Are you aware of that maximum penalty?
Yes, I am.
The benefit of the plea agreement is a couple of different things. First, the prosecutor dismissed count 1, which is alleged as delivery or manufacture of methamphetamine. Are you aware of that?
Yes.
Second, the prosecutor dismissed count 3, which is alleged as possession of a Schedule 5, the controlled substance psilocybin. Are you aware of that?
Yes, I am.
Third, the prosecutor dismissed the claim that you are a habitual offender fourth offense notice. If you were convicted as a habitual fourth, you would be subject to life maximum in the state prison system for count 1 and 2. Are you aware of that?
Yes, I am.
And then finally, the attorneys are asking me to engage in a sentence agreement where I would agree to sentence you within the guidelines range, whatever that guidelines range ultimately is determined to be by the court. Do you understand that?
Yes, I do.
So if for whatever reason I decided to sentence you outside of that guidelines range, I would need to tell you what your proposed sentence would be, and then I would give you the opportunity to either accept that sentence or to withdraw your plea altogether and go back to the proverbial drawing board about a plea negotiation. Do you understand that?
Yes, I do.
Do you understand the benefit of the plea agreement?
Yes.
Do you understand the maximum penalty you would be facing for count 2 as a habitual third?
Yes, I do.
Understanding all of those things, then, how do you plead to count 2, controlled substance delivery or manufacture of less than 50 grams of fentanyl?
Guilty.
If you plead guilty, you no longer have any automatic rights to appeal, and what that means is your appeal rights are limited. You would have to ask the Court of Appeals for what's called leave to appeal. You understand that?
Yes.
If you plead guilty, you give up all of your current trial rights. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have a right to have the witnesses against you appear and to see, hear, and question them, and you'd have the right to have the court order any witnesses on your behalf be ordered to appear at your trial. You'd have a right to remain silent at your trial and not have that silence used against you, and you would have the right to testify at trial if you wanted to. But if you plead guilty, you give up those trial rights. Are you aware of that?
Yes, I am.
And because you're giving up your right to trial itself, you also necessarily give up the right to challenge other things that might have occurred during your trial. Are you aware of that?
Yes.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yes.
Is it your choice to plead guilty?
Yes.
The prosecutor claims that this offense happened on March 12th of 2026 here in Kalkaska County. Do you think that date and place are accurate?
Yes.
On March 12th of 2026, and while you were in Kalkaska County, state of Michigan, did you first possess less than 50 grams of the controlled substance fentanyl?
Yes.
Did you know it was fentanyl?
Yes, I did.
Did you subsequently deliver or transfer that substance to someone else?
Yes.
Or did you possess it with the intent to deliver it to someone else?
Yes.
Counsel, is there an adequate factual basis? I'm sorry. Is it true also, Mr. Sizemore, that you previously to that offense, meaning before March 12th of 2026, you had been convicted of one felony offense in 2009 of possession of narcotics on August 17th of 2009 here in Kalkaska County?
Yes.
Were you also convicted of a separate felony offense known as uttering and publishing in October 6th of 2009, also in the 46th Circuit Court for Kalkaska County?
Yes, I was.
Counsel, do you believe there's now an adequate factual basis?
Yes, Your Honor.
And I would agree, Judge.
Do the attorneys and the reporters comply with the court rule regarding the taking of pleas?
Yes, Your Honor.
And I would concur.
And are either one of the attorneys aware of any promises, threats, or inducements not disclosed on the record?
No, Your Honor.
No.
Mr. Sizemore, I accept your plea. I find it to be freely, knowingly, and voluntarily given, and there's a clear factual basis to support a finding of your guilt. So the court accepts that plea, and I'll enter it on your record. The next step is the department is going to reach out to you there in the jail, and they're going to interview you. That interview will result in a pre-sentence investigative report being prepared. Make sure and go over that report very carefully with your attorney. After that report's prepared, the next step will be a sentencing hearing, and that will be done in person. So you'll be brought here to the circuit courtroom. Your attorney will be here, the prosecutor will be here, and I'll be here in person. Do you have any questions regarding any of that?
No, I do not.
Mr. Grimmith, anything further on this case today?
Except that I'd like to participate in the pre-sentence investigation process with Mr. Sizemore. I see Ms. Wilk is on Zoom, so she normally sends me an email and we coordinate when that is to occur. So I just wanted to inform that since I saw Ms. Wilk, she's participated on Zoom right now. Thank you.
That's fine. Is there any particular setup that you need in order to accomplish that?
I will get with him. I'm not for sure who's going to be assigned the PSI because we're still getting assistance from a lot of other counties right now. So we'll get that coordinated.
Okay. Anything else from the people?
No, Your Honor.
All right. You're all set, Mr. Sizemore. We'll see you at your sentencing date, which will be arranged shortly.
Okay, thank you. Have a good morning.
All right. Thank you, Judge.
Thank you.
Once again, good morning, everybody. Happy Wednesday. It is TCF Live, episode 328 this morning. We just keep piling them on. Let's continue to ride with Judge Hunter. Looks like we might have a new contestant.
Hernandez, a second.
Yes.
Mr. Hernandez, we're here for a status conference. If you know, we were going down the road of a potential plea when I think, as I recall, it came up that you may have had a prior marijuana conviction. And if so, we had the discussion about whether or not that precluded you from being able to be eligible for 7411. Do you remember that discussion?
Yes, sir.
Since that time period, have you remained in good contact with your attorney?
Yes.
Mr. Travis, in general, is that what happened at the last hearing? Is my recollection accurate?
That is correct. We're starting the process of entering a 7411 plea, and Your Honor asked Mr. Hernandez a question that I guess I didn't pointedly put to him. And it does appear quite likely there is a marijuana-related conviction out of Texas that is some years old.
So he would not be eligible if that's accurate for 7411. Is that accurate?
That is most, yes. It truly, if it was a marijuana conviction, it would be, and it looks like most likely it is.
So is there a different negotiation that the parties were able to get to, or how should I be proceeding?
Yes, Your Honor. And speaking of Mr. Ziegler, it's my understanding he would offer a plea to plead to the possession of methamphetamine under a delay of sentence. And if Mr. Hernandez completed a year term of probation successfully, he would dismiss the charge at the end.
Is that an accurate statement of the plea offer?
It is, Your Honor.
The general delay statute 771.1.
Correct, because he's not eligible for 7411.
All right. And you think I could make the findings? I'm sure you wouldn't offer this plea that it's not likely that Mr. Hernandez would reoffend.
Your Honor, his last conviction that's known to me is that marijuana conviction. It's from 2010 out of Texas.
All right, and you would also agree, Mr. Travis, that you think I could make the finding that this is not a case where it's likely that Mr. Hernandez would reoffend?
I do believe that, and I guess I could tell him, I didn't, just talking to Mr. Hernandez this morning, to that point, I should inform Mr. Ziegler. I think Mr. Hernandez has either pled to or is going to plead to a reckless driving in Grand Traverse County.
All right, I appreciate your candor in that regard. Does the fact of a reckless driving conviction have any bearing on your willingness or suggestion to sentence under 771.1?
It does not at this time, Your Honor.
Mr. Hernandez, did you hear the terms of the plea agreement?
Yes.
Do you understand the terms?
Yes.
Do you have any questions about the terms?
No.
Did you want to go forward by entering a guilty plea? So the two options you have at all times, Mr. Hernandez, in the criminal justice system, when you're faced with these types of charges, is you can demand to have a trial. And at the trial, the jury would determine whether or not the prosecutor could prove beyond a reasonable doubt that you're guilty, or you can enter into a plea agreement. The plea agreement's been negotiated by your attorney, but it's only going to be workable if you want to enter into the plea agreement.
Yes.
Because that calls for you entering into a plea.
Of guilty?
Of guilty, correct.
Yes.
If you want to accept that, that's what you would need to do. But you don't have to accept that. It's up to you what you do with this case.
I just want this to be over.
Well, I would like it to be over too. I have a duty to make cases get over, but there's two different ways to get them over.
I just
One
want
is
it the fastest way possible. I'm losing. I haven't been able to find a job since all of this started. I lost my car.
There's lots of things that are going on, but I need to make sure it's clear to you. This is not a case that we're just going to get done as fast as possible to get it done, unless what you decide to do after hearing from your attorney and talking with your attorney is that you want to resolve the case by pleading guilty, and I make the determination that you are guilty. But if the suggestion or implication from your statement is you're pleading guilty just to get this done, that's not a basis for me to accept a plea, and I won't do it. If, on the other hand, what you mean is you want to accept guilt under this plea agreement because you are guilty, and it will empower you to move on and get things done in your life in another way, that's okay.
That's exactly what I want.
Okay, I want to make sure the implications are clear and not open to any type of different type of interpretation. So you want to plead guilty because you are guilty,
Yes,
and you want to take advantage of the plea offer that the parties just indicated.
absolutely.
Okay. Mr. Hernandez, raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
So this plea would include you admitting guilt to count 2, which is controlled substance possession of methamphetamine. Are you aware of that?
Yes.
That is a felony offense. And if convicted, the maximum punishment you could face for that felony offense is up to 10 years in the state prison system and or a fine of up to $15,000. Are you aware of that?
Yes.
The benefit of the plea agreement is twofold. One, the prosecutor would dismiss count 1, which is assault, resist, or obstruct a police officer. Do you understand the benefit of that being dismissed?
Yes.
The second benefit is perhaps a more important benefit. Both are important, but perhaps more importantly, the prosecutor and the defense attorney are going to suggest to me that I should sentence you under what's called a delayed sentence. Are you aware of that?
Yes.
The statute is MCL 771.1, but what it allows the court to do is to delay imposing any punitive sanction, meaning I would put you on a term of probation, and I would delay doing anything like putting you in jail at the front end of the case. Do you understand that?
Yes.
I would put you then on a term of structured probation, subject to several different terms and conditions, including the full payment of fines and costs. Do you understand that?
Yes.
If you were successful in meeting all of those conditions, meaning you didn't violate probation, you stayed clean of any further criminal episodes, and otherwise maintained consistent contact with your probation agent, at the end of this case, the prosecutor would dismiss the case. It would be as if you were never convicted if you're successful on that delay. Do you understand that?
Yes.
If you're not successful on the delay, however, that gives the court the opportunity to revoke the delay. And if I revoke the delay, that means you would be sentenced on the possession of methamphetamine charge and be subject to the maximum penalties. Do you understand that?
Yes.
So potential reasons for the unsuccessful delay: if you get arrested, charged, and convicted with a new criminal offense, if you test positive for using drugs while you're on probation, if you otherwise violate any term of probation, or if you don't pay fines and costs within a reasonable time. All of those could potentially lead to you losing the delay status. Do you understand that?
Yes.
Did you still want to go forward with the plea agreement, understanding those terms, the potential benefits, and the potential risks?
Yes.
As to then count 2, possession of methamphetamine, how do you plead?
Guilty.
If you plead guilty, you no longer have any automatic appeal rights. Your appeal rights are instead limited, and you would have to ask the Court of Appeals for leave to appeal. Do you understand that?
Yes.
If you plead guilty, you give up all of your current trial rights. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have a prosecutor prove beyond a reasonable doubt that you are guilty. You have a right to remain silent at your trial and not have that silence used against you, and you'd have the right to testify at trial if you wanted to. You'd also have the right to have the witnesses against you be appearing at trial and to see, hear, and question them, and you'd have the right to have the court order any witnesses on your behalf to appear at trial. Do you understand all of those trial rights?
Yes.
And do you understand that you'll lose them if you plead guilty?
Yes.
And because you're giving up your right to trial itself, you necessarily also give up the right to challenge other things that might have occurred during your trial. Do you understand that?
Yes.
So, for example, if the prosecutor brought forth evidence that you thought was objectionable at the trial and I let it in, you could probably appeal on that basis. But because you're not having a trial, you wouldn't be able to appeal from anything that would have happened at a trial. Do you understand?
Yes.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yes.
Is it your choice to plead guilty?
Yes.
Is it true that you were present here in Kalkaska County on or about December 28th of 2025?
Yes.
On that date, did you knowingly or intentionally possess the controlled substance methamphetamine?
Yes, I did.
And did you know it was methamphetamine?
Yes, I did.
Counsel, is there an adequate factual basis?
Yes, Your Honor.
Yes, Your Honor.
Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, Your Honor.
And are either one of the attorneys aware of any promises, threats, or inducements not disclosed on the record?
No, Your Honor.
No, Your Honor.
Mr. Hernandez, I accept your plea. I'm going to provisionally enter that on your record. And what I mean is I want to examine a PSI, a pre-sentence investigative report, to make the final determination that I'll grant that delayed sentence. And I will do that after I get that PSI. You need to meet with the department. They're going to set up a time for you to interview with them. They're going to do the background review then and issue a pre-sentence investigative report, which will tell me more about you and more about your background. Then I'll have a sentencing hearing. It'll be about a month. It'll be just like we are here today, everyone in person. Do you have any question about any of that?
No.
Mr. Travis, anything else today?
Nothing further, Your Honor. Thank you.
Mr. Ziegler, anything else today?
No, Your Honor.
Okay, check in with probation before you leave, Mr. Hernandez, and then we'll see you at your sentencing hearing. Thank you.
Yeah.
Note that we have several individuals in their waiting room. One is David Riggs. Mr. Seeger, are you present in the courtroom?
I'm right here.
Are you ready to address Mr.
Well, they queue up the next contestant. Barbara, thank you for sending a turn it up with your jewels. And a dog mom sent a star. So thank you both.
JL add two. I'm not sure who the might be. I want to let the attorneys know. We'll bring them in to identify them in a moment. County Jail, sir or ma'am, can you hear the court? Welcome, sir. Are you Mr. Mercado Comer?
Sure.
Was that yes?
Yes.
Okay, I couldn't hear you very well. The audio is a little bit limited, so if I ask you to repeat yourself, that's the only reason. I just want to make a clear record. We're here on the matter of People of the State of Michigan versus Nichols, Christopher Mercado Comer. This is file 26-5196FH.
Brian Ziegler on behalf of the people.
Kevin Seeger appearing with me on behalf of Mr. Mercado Comer.
Thank you. So, Mr. Mercado Comer, we're here for a status conference today. You're lodged in the Wexford County Jail. Despite that fact, have you been able to maintain good contact with your attorney about this matter?
Yes, sir.
All right. Mr. Seeger, what should I be aware of about this case and how we should be proceeding?
Your Honor, it's my understanding that the people have offered Mr. Mercado an opportunity to plead to one count for possession of methamphetamine in exchange that balance would be dismissed.
Is that an accurate statement of plea offered?
It is, Your Honor.
Mr. Mercado Comer, did you hear the terms of that plea agreement?
Yes, sir.
Do you understand those terms?
Yes.
Did you want to take advantage of those terms by entering into a plea agreement?
Yes, sir.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Mr. Mercado Comer, under this plea agreement, you would be pleading guilty to count 1, which is possession of methamphetamine. Are you aware of that?
Yes.
In exchange, the prosecutor dismissed count 2, the weapons, ammunition, possession by a prohibited person. Are you aware of that?
Yes.
Count 1, possession of methamphetamine, is a felony offense. It's punishable by a maximum of up to 10 years in the state prison system and a maximum fine of up to $15,000. Are you aware of that?
Yes.
Understanding the benefits of the plea agreement and having count 2 dismissed and understanding the maximum penalty associated with count 1, what is your plea to count 1, possession of methamphetamine?
Guilty.
If you plead guilty, you no longer have any automatic appeal rights. Are you aware of that?
Yes, sir.
You also give up all of your current trial rights if you enter a guilty plea. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you would have the right to have the witnesses against you appear and to see, hear, and question them. And you'd have the right to have the court order any witnesses on your behalf be ordered to appear at trial. You'd have a right to remain silent and not have that silence used against you. And you would have the right to testify at trial if you wanted to. But if you plead guilty, those trial rights are waived in this matter. Are you aware of that?
Yes, sir.
And because you're giving up your right to trial itself, you also necessarily give up the right to challenge other things that you might have been able to challenge if you did have a trial. Are you aware of that?
Yes, sir.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No, sir.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
Is it your own choice to plead guilty?
Yes.
Prosecutor claims that this offense happened on April 12th, 2026 here in Kalkaska County. Do you think that date's accurate?
Want to say it was the 11th, but I think it may have been the 12th.
Okay. Well, on April 11th or April 12th, on or about that date, were you present in Kalkaska County?
Yes, sir.
And on that date, did you knowingly or intentionally possess the controlled substance methamphetamine?
Yes, sir.
Did you know it was methamphetamine?
Yes.
Counsel, are you satisfied that there's an adequate factual basis?
Yes, Your Honor.
Yes, sir.
Counsel satisfied that the court has complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, sir.
And are either one of the attorneys aware of any promises, threats, or inducements that have not been disclosed on the record?
No, Your Honor.
No, sir.
Mr. Mercado Comer, I accept your plea. I find it to be freely, knowingly, and voluntarily given, and there is a clear factual basis to support a finding of your guilt. The next step is the Department of Corrections is going to interview you there in the jail. That interview will result in what's called a pre-sentence investigative report, which will tell me more about you and more about your background. Then I'll impose sentence. The sentencing hearing will be an in-person proceeding, so you'll be brought here to the Kalkaska County Circuit Courtroom. The attorneys will be here in person, and I'll be here in person for that hearing. Do you have any questions about any of that?
No, sir.
All right, we will see you at your sentencing hearing then. Anything else, counsel?
No, Your Honor.
Your Honor, the only request that Mr. Mercado Comer had was whether or not he released any treatment in advance of sentencing. I think that it may be technically difficult only because there was a probation hold on him in Grand Traverse County.
Well, what's the probation hold regarding? I mean, what's he on probation for example?
I believe it's another possession charge, Your Honor, for which Mr. Scott is his probation officer.
Mr. Ziegler, did you want to be heard on the potential request?
Your Honor, I think given the fact that he was already on probation for another drug offense, I think we should get through the sentencing process before we talk about releasing Mr. Mercado Comer anywhere.
Mr. Mercado Comer, I'm not opposed to treatment sometimes in lieu of jail or potential sentencing options, other sentencing options, but I need to know more. I don't yet know exactly what you're on probation for. I know your attorney suggested he thinks it's another possession case, but I don't know or have any idea what Grand Traverse County or what the other county may do, and I don't know what I'm going to do. I don't know what your guidelines might look like. I don't know about your background. So I'm not foreclosing treatment in any way, but I think it's a better idea for me to have a better picture of what's happening in other counties and in this county before I make that determination. So I'm certainly willing to hear from you and your attorney at the sentencing hearing, but I'm going to wait until then to make a determination about treatment, unless and until I'm presented much more information. Thank you, Mr. Mercado Comer. We're all set for today.
All right, thank you.
Good morning once again, everybody. TCF Live on a Wednesday where Ashley is celebrating 15 months with us. She says, love you all. We love you too, Ashley. I've said it before and I'll say it again. This place does not function without you. Now, that having been said, I think Great Granny hit it on the head, though. She said, Ashley, 15 months with TCF and Dan is a wonderful accomplishment. She is not wrong, because most people would have gotten sick of me and moved on in half the time. So, seriously, though, thank you, Ashley. I appreciate you. Let's change it up a little bit. Stay in Michigan, Judge Simpson.
Russell Norville.
Oh,
Properly retired, but go ahead.
thank you, Ed. We are here for sentencing. The only update to the pre-sentence report is that Mr. Norville has recently started working just part-time as a pizza delivery driver. So that would be our only update. And then besides that, we would be asking that the court follows the recommendation. Mr. Norville can make a $50 payment towards his fines and costs today, but then he can.
Oh.
And then we'll need the length of probation to finish paying the fines, costs, and restitution.
Sir, anything you want to say before I impose sentence?
Just sorry for the whole situation. I'll take what I deserve.
To sentence of the court as to count 3, the retail fraud 3rd degree, sentence the defendant to 9 months probation, $480 fines and court costs, $270 probation oversight fees, $179.97 restitution to Meyer payable through the court. You have 50 today?
Yeah, I can pay that on card. Yes.
Is that
Pay it on card? I don't have cash.
okay?
Restitution.
You need to get the restitution paid off, but $50 today, then payment plan is arranged by probation.
Okay.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Beyond Barriers program or a comparable program. You're to complete 25 hours of community service as directed by probation. You're not to go to any Meijer store in the state of Michigan. You are to, not to go to any Meijer store in the state of Michigan. I'll order 93 days suspended. On the count 4 retail fraud 3rd degree, place you on probation for 9 months, $480 fines and costs that be on probation payment plan. You're to comply with all of the terms as set forth in count 2 or count 3, which I just enunciated to you. I'll order 93 days in jail suspended. Thank you.
Your Honor.
Court calls the case, People versus Tayshaun West.
Good morning, Your Honor. Robin McCoy on behalf of Tayshaun West, who is to my right, P633057.
Okay.
Good morning, Tayshaun West.
Yeah. Go ahead, Mr. McCoy.
Yes, Your Honor, we did have the opportunity to review the pre-sentencing report. There are no additions, corrections, or deletions. He is still gainfully employed, taking care of his daughter, and trying to stay out of trouble.
Sir, is there anything you want to say before I impose sentence?
Yeah, I'm highly apologetic for the situation I put myself in. And working every day to do different and better. So
Sentence of the court to place you on 9 months probation. You are to pay $555 fines and costs, $270 probation oversight fees. When can you pay that?
Yes.
Pardon?
Yes.
Well, can you pay it today?
I pay half of that today.
Pardon?
I pay half of that today.
You have the whole amount, or you just want to pay half?
I mean, I can have the whole amount, but I didn't want to pay it right now. I can right now if I have to pay it right now.
You want to use the money for something else? No, that's okay. But would you rather owe somebody else or me?
I would rather not owe anybody.
Yeah, you don't.
There you go. Okay, so pay it today.
Okay.
There should be no use of any alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete the Beyond Barriers program or comparable program. You are to complete 25 hours of community service as directed by probation. You're to maintain employment with proof to probation. I will discontinue the GPS tether. I'll order 93 days in jail. Credit to the balance is suspended. Okay. Thank you.
Thank you, Your Honor.
All right, friends, we will probably come back to Judge Simpson at some point, but let's go down to Jackson County, Florida. It is Judge Joe Grammer this morning handling first appearances.
Short docket. We'll get to everybody pretty soon. What's your name, sir?
Willie Smith.
Larry Crainer.
No. I'm sorry. I was asking your client. I just saw Mr. Smith. Mr. Smith, how are you doing this morning?
I'm all right. How you doing, sir?
I'm good, thank you. You're charged with domestic violence, battery by strangulation, punishable by 5 years, $5,000. You have the right to remain silent. Should you give up that right, anything you say can be used against you. You have the right to an attorney and to have one appointed for you if you cannot afford one. An attorney is on the line with you. Mr. Smith, you have...
Trainer.
No. Your client's Mr. Smith.
Okay.
Okay. I'm looking at him. I can't see you, so I'm looking at Mr. Smith. But I'll give you a chance to speak in just a moment, Mr. Smith.
My apologies.
That's okay. Mr. Smith, you're here. You've got a history, including lots of drugs, several times charged with battery. Looks like you're on probation from Calhoun. Is it from Calhoun County?
Yes, sir.
Okay. What is that? Is that the battery charge you had earlier this year?
Yes, sir.
Misdemeanor? Okay. Good deal. All right. Mr. Crainer, you want to say anything about Mr. Smith before I set bond? I am going to find the warrant was already issued, so probable cause was found by Judge Mercer. But go ahead if you have anything you want to say.
Nothing to say at this time, sir. Thank you very much.
Okay. Mr. Crainer, Mr. Smith, one of the things I'm going to do is pull up that Calhoun County violation of probation, and I'll do a VOP warrant for Calhoun County on this case. There was a call that came in from somebody. We don't know if it's really who it says it was, Crystal McDaniel, saying that this didn't happen. So that's something the state will have to take into consideration. At this point, your bond's set at $15,000. You'll have no contact whatsoever with the alleged victim in this case. I don't know what your next court date is.
Your Honor, as also we request that a 7-day hold be put in for the VOSP warrant to be set out in Calhoun. That's usually what we do if we don't see a warrant.
I'm going to do a warrant today.
Okay, the warrant's going to be done today. Yeah. Okay.
August 4th is
August the 4th will be your next court date then, sir.
May I speak on something, sir?
Yes, sure. Hey, be careful though. Remember, I advised you of your right to remain silent, so anything you say can be a problem.
I was just asked about how I do that with my children, like how I do that with my child. Because she has custody of my child that I have with another woman. So.
You mean how you have no contact?
Yes.
Well, that's a good question, but that's not one I can resolve it this morning. At this point, there's no contact, and then we'll figure that out later. Okay.
All right.
All right. Take care, sir.
Thank you, Your Honor.
You're welcome. You have any forms or anything that I sign on?
Case as the victim.
I think this.
Hey, Lawrence.
Good morning, Judge. How you doing?
Good. How are you?
Good.
Judge Grimmer, I think this is actually the alleged victim for Willie Smith right here.
Yes.
Okay.
I think she said, did you want to say something?
Did you want to be heard?
I did.
Okay. Can you step up to a microphone somewhere? Wherever you want to put her? Go right at the front. Hi, what's your name?
Crystal McDaniel.
Okay. And what did you wanted to say?
I just wanted to
Glasses off your head.
okay, I apologize. I just wanted to notify the court the allegations and statements made against him were false, and I am not a victim. I do not wish to be recognized as a victim, and I have wrote a statement to the state's attorney and been in contact with them since the allegations were made.
Okay. I'm looking at now. Give me just a second. I'm trying to find this. Do you have some ID so I can tell you're really who you say you are?
In my car, yeah.
where you can go get it and come back with it.
Yes, sir.
Okay? I mean, in my experience, I've had people show up and say they're people that they're not.
Yes, sir.
In a case just like this. So you'll have to tell me who you are. I don't know that it's going to make any difference, but I would like to give you a chance to identify yourself. So
Yes,
go
sir.
to your car and then we'll call you up when you get a chance.
Okay, thank you.
All right. Next case.
I think this is Tevin Ross.
Yeah, that was still Mr. Smith. All right, what's your name?
Tevin Ross.
Hello, Mr. Ross. You're here on I believe, if I can read this right, on a warrant out of Bay County, charging you with conspiracy to traffic in methamphetamine more than 400 grams and unlawful use of a two-way device to facilitate a felony. So, trying to pull that up. So the first appearance stuff's not on here. It's not in the docket yet. Okay.
Well, I mean, yes, it's not. And
It's just not as a docket. I mean, I can find his case, but let me find out what 03, that's the Bay County case. I got it. It's case number 262045. And your other case that you have in Jackson County is very similar. And I believe that your bond up here is over $1 million total. Is that right?
1 million, yes, sir.
Okay. Yeah. All right. So what's going on here is you've got cases in both counties, and there's a suggestion by the state that we should go ahead and send you to Bay County and let you deal with that first. Leave a detainer on you for Jackson County. Do you have the ability to get out of jail here on the Jackson County case with that $1 million bond?
No, sir.
Okay. So what we're going to do for Bay County, we'll just hold you without bond, and I'll do an order to transport to get you down there. And that should keep you from having a failure to appear when your next court date comes up here, which is October the 6th. Oh yeah, we should be able to get things done down there before October the 6th. So you'll be held without bond on the Bay County warrant. And again, I'll do an order to transport. Okay?
Yes, sir.
Take care, sir.
Jeffrey Tipton.
Hello, Mr. Tipton. This is case number 25236. It appears that you violated your conditional release by not showing up for arraignment. Judge Mercer's ordered that you be held without bond. We will hold you without bond. What's our return date on that?
Your Honor, if you're willing to accept that there is a plea agreement.
You got a plea?
Yes.
Okay.
I believe Mr. McDaniel will put it on the record.
Okay.
Your Honor, I spoke
Mr.
to Mr. Tipton. I spoke to Mr.
Is that
Tipton.
you, John?
That is me, Judge. It's good to see you again now.
Oh, you're right in there. Okay. I didn't even notice that was you. Okay.
Yes, sir.
Good. I thought when I saw you in that outfit, you were jail personnel. I'm sorry. Let me go through this with Mr. Tipton. Mr. Tipton, you've applied for the public defender. Is everything in your affidavit correct?
Yes, sir.
Do you wish to have the services of the public defender?
Yes, sir.
Okay. I will appoint the public defender to represent you. Go ahead, John.
Your Honor, I was talking to Mr. Tipton. At this point in time, he's charged with driving a license suspended, revoked. He's going to plead no contest to that charge. The understanding he's going to be sentenced to 6 months in the county jail. They have 4 days jail credit to be a $400 fine, which hopefully he'll work it off while he's here in the trustee bay. He has signed his plea waiver, waiving his right to a jury trial. We call witnesses, and that'll resolve this case this morning.
Mr. Tipton, did you understand the announcement of your just appointed attorney?
Yes, sir.
Are you satisfied with his services?
Yes, sir.
Are you under the influence of any drugs, medications, or alcohol?
No, sir.
Is there anything about you today that would keep you from understanding what's going on?
No, sir.
Okay. I find your pleas freely and voluntarily made with knowledge of the consequences. There's a factual basis based. Do you have a hard pen I could use? I just use these fountain pens. They won't work. Thank you. Based on the I'll find that you plead freely and voluntarily made with knowledge of the consequences. There's a factual basis based on the citation. You are adjudicated guilty. You're sentenced to 6 months in the Jackson County Jail with credit for time served of 4 days. Your fines, fees, and cost order amount to $400. We'll reduce it to a civil judgment if you don't work it off. Do you have any questions?
How they about 4 months?
No questions,
No
John.
question.
If you don't behave, it'll be all 6 months.
Okay.
Behave.
Okay.
All right.
Ma'am, come on up. Bring your ID.
Willie Smith.
Just we'll be right with you. Give your ID to the deputy, to the sergeant, please. That appears to be her.
Yeah, that appears to be her.
Smith, we've got the alleged victim in here. She has identified herself. And she has told me that these allegations are not true. I haven't seen the complaint. Maybe I should look at that.
It's not in the first appearance packet, but I do have it pulled up if you want me to.
I just figured I can find it by name. Let's see. Okay, what's the case number?
There's a case number right there, Judge. I don't know if that was it.
Oh, that's this one? Okay, sorry.
Do you have those notes that you showed to our victim advocate?
So I previously filled out a piece of paper stating that I did not wish to pursue charges. I never pressed charges, and I didn't wish for any to be pursued. Since then, I received a victim impact statement letter in the mail.
Can I see it one?
And I wrote a written statement.
Okay, I'll read it while you're talking with the judge.
Okay.
Oh, that's the wrong county.
Judge, would you like to see the note as you wrote?
Okay, I've read your note and I'm also reading the complaint in which the officer related many things that you said, which would constitute battery in this case. So I'm going to leave my bond set at $15,000. I am going to do the warrant for Calhoun County and file that today. Okay, thank you for coming in.
Thank you.
Misty Mariel.
Hello, ma'am. You're here in case number 26131. It is a possession of methamphetamine. You allegedly failed to appear for your arraignment. Judge Garcia's ordered that you be held without bond. You will be held without bond to return on. Is that August 4th as well? Is that okay? August 4th. You have the right to remain silent. Should you give up that right, anything you say can be used against you. You have the right to an attorney and to have one appointed for you if you cannot afford one. Are you interested in the public defender's office?
Judge, I think she's been appointed Miss Simpson for this case yesterday. They had arraignment court yesterday, and I don't know if there was confusion, but Miss Simpson's office, she says, told them to be there at 1 o'clock. But in any event, I'm gonna let Miss Simpson know that she's over here, and she'll come by and speak to her and see if they can't figure out what happened.
Okay, so Miss Mariel, do you believe you have Miss Simpson as your attorney?
Yes, actually, she is my attorney. She did call me and speak to me and tell me that my court date was yesterday, which was July the 7th at 1 o'clock. The correct information was July the 7th at 8 o'clock in the morning. Somebody should be in the courthouse now with the recording that was left on my voicemail. I'm not sure exactly.
Additional information.
Okay.
So Miss Mariel.
Miss Mariel, just be quiet for a minute, please.
Miss Mariel failed to appear last arraignment court date in June. Judge Garcia gave her an opportunity and her attorney to come up with a valid reason as to why she did not show up. She provided a hospital note from Jackson Hospital where she was there for 1 day and was allowed to return to work the next day, the day of court. Judge Garcia said she needed more information before she would not issue a capias. That brings us to yesterday where Miss Mariel was supposed to be in court. And again, she was not there at 9 a.m. So at that point, Judge Garcia put out the capias for her arrest. So this was not just a one-time.
Miss Mariel, your attorney, if you have Miss Simpson, she can file whatever is necessary to the court. Get that in front of Judge Garcia, okay? Your next court date is August 4th, okay. August 4th.
Thank you, Your Honor. Anthony Ingle. Anthony Ingle.
Man,
Hello, Mr. Engel. How are you this morning?
Good morning, sir. I'm doing well, thank you.
You're here on a violation of probation warrant. Judge Garcia says to hold you without bond. That's case number 24-438 and 24-474. You will be held without bond to return on August 4th, I believe. 6th. It's a different day for VOPs? Okay. August 6th. I'm just not going to guess anymore. Would you like the public defender to be appointed to represent you?
I believe I've already requested that. Yes, sir.
Okay, you did request it, but it hasn't been ordered yet. That's why I'm asking you the questions. Would you like the public defender?
Yes, sir. Please.
All right, your listed income of $2,000 a month. What is it that you've been doing to make that money?
I work for a lawn care company in Panama City. I've been working with them almost 2 years. I'd also like to request a compassionate care release. My wife is blind. My son is mentally disabled, and I'm their primary caregiver.
That's not going to happen today. If I appoint a public defender, your public defender can address that with Judge Garcia. Do you have a car, truck, boat, plane, anything like that, motorcycle?
I do have a vehicle, but it is not operational.
Okay, what year is it? What kind of vehicle?
It's a 2001 GMC pickup.
Do you have any land or property other than your homestead?
No, sir. I have no property, no assets.
Okay, I will appoint the public defender's office to represent you. All right, sir, your public defender can address that issue that you have about compassionate leave.
Thank you.
All right, you're welcome.
August 6th. Timothy Granger.
How you doing, John?
I'm good, Mr. Granger. How are you doing?
All right, all right.
Two things you got going on. One is this new case, which is possession of methamphetamine. And I had your case number here somewhere. Not on that docket, unless, no. Also, you're apparently currently out on bond on another case.
Yes, sir.
Which is 2524. On this case.
This new case, Your Honor,
Yeah.
the person actually owns.
Hold on. I don't know that I advised you of your rights yet. So if you're going to say something incriminating, I need to make sure I tell you that ahead of time. You have the right to remain silent. Should you give up that right, anything you say can be used against you. You have the right to an attorney and to have one appointed for you if you cannot afford one. And do you have the public defender on that other case, 2524?
He has been appointed, Don Dennis, so he does have an attorney, a conflict attorney.
Okay. So if you want, I can't just appoint Mr. Dennis in here until the public defender says they've got a conflict in this case. So I'm going to appoint the public defender and let them file the proper paperwork to get you probably get Mr. Dennis on that case as well. Okay. So if you want to say something, I'll listen to you. It's just not a good idea.
Yes, sir, I'd like to speak.
Okay. Go ahead.
Mr. McDaniel's quick with the mute button. That's what it is.
Probably a good idea.
Judge, I advise him not to speak, but he wants to speak, so I can't stop him.
I believe in things to being heard should be heard, Your Honor. I was charged with possession of methamphetamines whenever it's not mine. And the person that actually was with me is actually stating that it is hers. It's not mine, and they're holding me for no reason.
It's not ownership of drugs that is the crime. It's the possession of it. And I'm not going to adjudicate that today, but there are two separate amounts of methamphetamine. There's one that's you're charged with, which is about 3 grams, and there's one that she's charged with, which is about 0.5 gram, based on that. But I'm finding probable cause to go forward on that today. And on your other case, what is the case that he's out on bond on? It's 2524, but what kind of case is that?
It is an armed trespass, felon in possession of a firearm or ammunition ×2, and possession of paraphernalia.
Okay. In case number 2524, I'm going to do an order today that revokes your bond and holds you without bond. On this one, the case before me today, I'm going to hold you on $10,000 bond. Your next court date is whatever your other court date is. Will you do both of them the same day?
Good. I don't know if he's when his next court date is.
Probably
John, do you have any other?
August 4th. It needs to be arranged so we can get him a conflict attorney. So, appoint Mr. Dennis to him. So August 4th.
But as long as the person accepts
August 4th.
That's it, right?
No, that's not it.
No, I'm talking about
that's not it.
They say it, sir.
It'd be up to the state to decide whether to go forward. All I did today was find probable cause to proceed and to hold you on that bond that I set. Okay.
Your Honor, what was that bond amount?
10,000 on this case, but I'm going to revoke the other one and hold him without.
August 4th. Stephanie Rossman.
Hello, Ms. Rossner. How are you this morning?
Hey, thank you.
You're here charged with possession of methamphetamine, specifically as alleged it's 0.56 grams. You have the right to remain silent. Should you give up that right, anything you say can be used against you. You have the right to an attorney and to have one appointed for you if you cannot afford one. Based on the information you provided, you do qualify. Would you like me to appoint the public defender to represent you?
Yes, sir.
I will appoint the public defender's office to represent you. I think that Mr. Granger has another attorney, so the conflict will be, in his case, the public defender should be able to represent you here, but that's up to them. All right. So I saw that you went to prison for methamphetamine in 2020. Is that right?
Yes, sir.
Okay. You're not on probation or anything at this point?
Yes, sir.
All right, I find that there is probable cause to proceed in here, set your bond at $10,000. Your next court date is going to be August the 4th.
Your Honor, we would also request she have a condition of random UAs.
Okay, we'll order that, random UAs. It's a good idea as ordered by the court. All right. Take care, Ms. Rossner.
Tyrone Jackson.
How you doing this morning? Hello, Tyrone Jackson.
Yes, sir.
You're here today in case number 23-231. That is a violation of probation warrant signed by Judge Garcia. She ordered for you that you be held without bond. You will be held without bond to return on August the 6th. You have the right to remain silent. Should you give up that right, anything you say can be used against you. You have the right to an attorney and to have one appointed for you if you cannot afford one. You do qualify for the public defender. Would you like me to appoint that office to represent you?
Yes, sir.
Okay, I will appoint the public defender's office to represent you. Take care.
Yes, sir. You as well.
Thank you.
Trials, we got Deontay Bellamy.
So the ones that you need to see.
Okay. Good deal. All right. Deontay Bellamy.
Yes, sir.
How are you this morning?
Doing good. How you doing?
I'm doing fine, thank you. Looks like your case number is 26-325. You're charged with stalking and trespass. You had an offer made for 6 months in jail. But this says that you thought you had a private attorney, but Mr. Ballack hasn't actually filed anything on your behalf. Okay. So, wait a minute, let's see. Nope, that's his notice to bear. Okay, so right now you don't have an attorney to represent you. Have you previously applied for the public defender? Or do you want to hang on and hope Mr. Ballack files something on your behalf?
Yes, sir. We're gonna hang on.
Okay. So I guess you're going to continue your plea of not guilty since the attorney you want to have is not here. Your next court date will be, do we need to set him on for a trial or we need to put him on another pretrial?
I think just a
August 12th, pretrial.
August 12th. Okay.
Okay, we're going to set you for August 12th. All the conditions of your case are still in effect. Take care, sir.
Also, case number 2620, he's got a violation of county probation listed on the August 12th.
No, I see it. Okay.
All right. Good luck to you, man.
Thank you, John.
Nichols, Tyndall.
It's almost Kelly on the line. That is her case. She may still be there.
Amanda?
Good morning, Your Honor.
Good morning. How are you?
I'm okay. How are you?
I'm good, thank you. What's going on with Mr. Tyndall?
The last time I met with Mr. Tyndall, I had not received this discovery yet. I've received it. This charge is a kind of a companion to a felony charge that we've got scheduled for next week with Judge Young is covering. I guess Judge Garcia had recused herself. He's got court next Tuesday. So if we can just get him a court date on the misdemeanor for a date after that, whatever Mr. Mitchell suggests.
That works with me. We can set it for the August 12th. We can do that.
Okay. So, Mr. Tyndall, did you understand the announcement of your lawyer?
Yes, sir.
And I'll be out to see you tomorrow, Mr. Tyndall.
Yeah, next Tuesday they'll have you in circuit court, and there's a possibility maybe they can work it all out if you're willing. Take care.
Yes, sir. All right, thank you.
And Your Honor, I just want to clarify, Amanda, we have sent discovery over. Just get with your office and they should.
Yeah, you've sent it now. You just hadn't the last time I was at the jail. But it was within the 15 days. Yeah.
She said she's got it.
Yeah.
Okay, my apologies.
And then I spoke to Officer Gross this morning, and they did not bring Mr. Polnitz to court, and they cleared that with me. So.
Okay. So Mr. Polnitz is not here, but his lawyer is here on his behalf. What should we do with Mr. Polnitz
Your Honor,
today?
Mr. Polnitz is currently held without bond. He was out on bond at a DUI and picked up a driving on suspended license. I'm sorry, I'm trying to find the case numbers one-handed. It's 26007 CT and 26208 CT. He is incompetent. He's been declared incompetent more times than I can count. He's been declared so incompetent that one of the judges over in the First Circuit wouldn't even let him testify as a victim. So I'm not sure what we do. I'm going to file the paperwork to have him evaluated again, but the state hospital won't take him on a misdemeanor. I can't plead him out because he's so incompetent. And so we're just kind of stuck.
Well, I guess the next thing we need to do is put him on another court date. If you file the paperwork, then Judge Mercer will be able to look at it and say what to do with him.
Okay.
August 12th.
Okay. Thank you, Your Honor.
Thank you.
All right. Y'all have a great day.
You too.
That's all we got, Judge.
Thank you very much. Good to see you again, John.
Good to see you too again, Judge. I appreciate it.
Yep. Take care.
Y'all have a good day now.
Thanks.
All right, friends, that was Judge Joe Grammer, the first time we've had him on the channel. Maybe we'll get to see him again at some point. Let's go up to Lake County, Ohio, and Judge O'Donnell. Well, Judge O'Donnell's got an audio issue. That's unfortunate. I guess we won't spend any time with him. Let's go to Michigan then. Judge Mertz holding court in the converted pole barn today. Let's do that.
Tell me your name, please. Luther Jones. Mr. Jones, okay. We'll go on the record in People versus Luther Jones. This is file number 266961. The record should reflect that Mr. Jones is present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Roger Jones, I call back people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Jones.
Great. Mr. Trush, can you tell me the status of this file today?
Your Honor, at this time, we're going to ask the matter be docketed for a trial. I'm still somewhat optimistic we may be able to come to a resolution, but I feel like we've kind of been in that position for a little while here, and deadlines are going to get things done. Either we're going to be able to resolve it or not.
Okay. How much time do you need, Mr. Trush, to be ready for trial?
I don't have a specific time frame based on where I'm seeing the court schedule. I'm assuming it'll probably be about 90 days down the road. But there's no specific time frame.
That would be enough time as soon as I can get it scheduled for you.
Yes.
Okay, Mr. Rolla.
I agree, Your Honor, that's correct.
Okay. How many days of trial?
That 1 day trial, we have 1, 2, 3, 4, 5, 6, 7 witnesses. So I think that's probably a simple.
Mr. Trush.
I would tend to agree with that. And frankly, I think the issue here is probably fairly narrow. So my guess is at least some of those witnesses may not be necessary because we'll likely stipulate to some things.
Okay. Okay, so we'll set it for a 1 day jury trial. The court's next available date, which will probably be about 90 days. The court will set it for a final status conference. Prior to the trial date, that will be the plea cutoff and the motion cutoff if any parties have any motions. Mr. Rolla, any other matters for scheduling from your side?
Not in this one, no, Judge.
Mr. Trush.
No, Your Honor.
Mr. Jones, were you able to hear everything that we said?
Yes, sir.
Do you have any questions about how we're going to proceed with your case?
No, sir.
Okay. All right, so your next appearance in court, Mr. Jones, will be for a final status conference. That'll be just prior to your trial date. At that status conference, I will be asking you whether you want to enter into any plea agreement, and I just final decision on that date, okay? Okay. All right, thank you. That's all for this hearing today. And I think Mr. Wadesky is next.
Yes, sir.
Okay, thank you. Okay, on the tablet there, can you unmute, please? Here we go. Can you tell me your name?
Brian Phillips.
Okay, we're on the record in People versus Phillips. This is file number 226358. The record should reflect Mr. Phillips is present today by video. Mr. Church, can you tell me the status of this file?
Thank you, Your Honor. Mr. Phillips was released from the Grand Traverse County Jail, I think a little over a week ago. The last conversation I had with him in the jail, we had discussed a motion he wanted to be filed. That motion has been drafted. I haven't filed it because I have not been able to communicate with him since he got out of the jail. He called me and let me know when he got out. I've tried to reach him back at that number a couple of times and haven't got a hold of him. Again, the motion is drafted and ready to be filed, but I did not want to file it without discussing it with him because ultimately the prosecutor's standard operating procedure is once that's filed, they're taking any offers off the table. But again, based on my conversation with Mr. Phillips, I believe what he wants is for a trial to be scheduled and that motion to be filed.
Mr. Phillips, were you able to hear that?
Yeah.
Is that how you wanted to proceed?
I'm not entirely sure what to do. Can I have a second? Do you guys do the breakout room or whatever? Could I have a second with my attorney? I've tried calling him, he's tried calling me, but I haven't been able to talk to him, so I don't really know how to proceed, to be honest.
Okay. Yep, if
sorry.
you want to stay on the line when we have a break, I can put you into a breakout room with them.
Is that okay? Sorry.
Yeah, that's fine.
Okay, thank you, sir.
So I'm going to put you back on hold for a minute.
Okay.
All right, good morning once again, everybody. Now in hour 2 of TCF Live here on this fine Wednesday. Let's take a break from court for a second. Last summer, we monitored this this place. Hold on. There we go. Had something running in the background. Needed to be muted. It was bothering me. Anyways, last summer we monitored these guys a lot. They're back. Say good morning to the Bears up in Alaska. Spend a minute or two with them. Good palate cleanser. All right, friends, we'll keep an eye on the bears. That's Katmai National Park up in Alaska. They have a live feed of the bears every day, so if you're at all curious, it's easy to find on YouTube. Do check it out. Good relaxing time. All right, palates cleansed. Judge West has a trial this morning, but it looks like before that she's got a contestant that needs to be dealt with, so let's take a look at that.
Are you William Leroy Jones?
Sorry.
And let's see, Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Jones, in cause number 25, DCCR 1627, you're charged with the state jail felony offense of theft of property with previous convictions from August 3rd of 2025. The indictment alleges you were previously convicted of theft, 2 cases on June 1st of 2023, and then November 16th of 2023, August 6th of 2024, and then 2 cases on August 15th of 2024. And how do you plead to that charge?
No contest.
You're either guilty or not guilty.
Guilty.
Are you pleading guilty because freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Then we have cause number 25, DCCR 1628. And in that case, you were also charged with the state jail felony offense of theft with previous theft convictions from August 2nd of 2025. The indictment alleges all those same prior convictions. And how do you plead in that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then finally, we have cause number 25, DCCR 1629. And in that case, you're also charged with theft of property with previous convictions. That's from August 9th of 2025. The indictment alleges those same prior theft convictions. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In all 3 of those cases, I have here on the tablets documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
I did.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
I understand.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection, ma'am.
It's admitted in each case. Is there any evidence that Mr. Jones is not competent?
No objection.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Also find that those prior convictions are true. In cause number 25, DCCR 1627, find sufficient evidence to find you guilty, and at this time find you guilty of theft, state jail felony offense of theft with previous theft convictions. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 25, DCCR 1628, also find sufficient evidence to find you guilty, find those prior convictions true, and at this time find you guilty of the state jail felony offense of theft with prior theft convictions. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 25, DCCR 1629, find sufficient evidence to find you guilty, find those prior convictions true, and at this time find you guilty of the state jail felony offense of theft with prior theft convictions. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I have signed a dismissal as part of this plea agreement in cause number 25 DCCR 1630. I'm handing you the trial court certification in those cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Obviously, Mr. Jones, you can see that the thefts are only going to continue to get you in more and more trouble, more and more time in prison. You've got, I think, this is your 10th, something like that. So, do your time, get out, and stop, because you're going to be in here doing a whole lot more time if you don't.
Yes, Judge, thank you.
All right, you can go back with the bailiff.
Thank you, Your Honor. Thanks, Judge.
And we can get Mr. Asa Jones out.
Yes, ma'am.
Start with a file. Okay, we'll get ready to go.
All right, friends, that's all she's got for today, because now she's going into trial mode. But let's go across the hallway to Judge Stevens. But before I hit the go button on him, that's where I've got him paused at. He has the best facial expressions, you have to admit. He is, he's almost like a claymation character sometimes, or maybe a Muppet, something like that. He's definitely a creation of the Disney animatronics team, if nothing else. Anyways, Judge Stevens.
Always one month. And in the Criminal District Court of Jefferson County, Texas, we are ready to proceed, and we're going to call first cause number 26 CR 1313, the state of Texas versus Joshua Strong Gibson Jr. That is you, sir?
Yes.
You are here with your attorney, Mr. Walker, and the state's attorneys. Does the defendant, what are we doing today? Is this a disposition plea? Does the defendant waive a formal reading of the indictment and the arraignment here in this case? Can we proceed in summary?
He does, Your Honor. Yes, we can.
All right. Mr. Gibson, in summary, this indictment, and you are probably intimately familiar with what it says. It was handed up in January of this year by the grand jury. And it states that on or about November 24th of 2025 last year in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you are charged with here?
Yes, sir.
This was a motorcycle you were on? My father told me how to get me in trouble, a motorcycle.
It was good. Yes, Your Honor.
Yeah, I'm looking at 110 miles an hour in this probable cause affidavit.
Yes. It was a stupid mistake.
Well, it's just, you're a smart enough guy. You know that that's reckless, and if you don't hurt yourself on a motorcycle at 110 miles an hour, try to stop when a vehicle in front of you hits its brakes, right? And then you slam in, then you go over the car and hit whoever's standing around, and it's a catastrophe. I don't need to tell you about that. You know. Plus, it kills your insurance. Find out. I mean, the cost is just not worth it. What can happen? Who's that guy? Who's that guy? Like, who's that guy?
Involuntary wallet. He's hard to tell.
He's the one holding your wallet.
Yes, sir. That's true, and has been for years.
Oh, what a great family. Oh, don't do this again. You know, I mean, you just put yourself at risk, but others too. Losing the control of a motorcycle at 110 miles an hour, there's hardly an option other than death. You're talking to you like your parents, I know. So I'm sure you've heard this one. Probably. Why? Because we care about people's well-being. And you've never been arrested before, have you?
Yes.
You hesitated for a second. No? Okay. How'd that work out for you in this case? You don't want that, do you? That's embarrassing and time-consuming, and then it's a record out there that's you don't want to have circulating around when you're trying to get jobs and move up in life. All right. If convicted of this is a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you are facing? It's up to 10 years in prison. They treat this seriously. You don't want to do 1 day.
Yes.
1 hour. An agreement has been reached between the parties that you would be pleading guilty but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. Is that your understanding of the agreement?
Yes, sir.
There would be terms and conditions of probation which are normal, customary for this type of offense. And some of these terms and conditions of probation will be, well, all of them are in your best interest, but some of them will help you a little bit financially.
Yes.
The way I did. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
Follow this agreement. Get through, do this, get it behind you. If you fail, your probation could be revoked. You could then be found guilty of this felony offense, which you carry the rest of your life, and you can go to prison up to 10 years. All of that ought to be nightmarish. Oh,
yes, sir.
Good. You understand. Fix it.
Yes.
You made a mistake. Fix it and move on. Do the best you can. Because you're better than making a mistake like this. How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you it's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
Okay.
Without objection, it's admitted. Among other things, this state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied, it states, with the representation by your lawyer. All of this is true, this state, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes,
Here?
sir.
Yeah.
Absolutely.
All right, Judge muted himself. Let me see if I can push back past that rather. We're a few minutes in the Wayback Machine.
Competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. That would be guilty for the rest of your life. You would have to carry it around. But the court is going to instead defer any finding of guilt so long as you follow the terms and conditions of probation in this deferred or unadjudicated probation order. You will be placed on this probation for 6 years, and it can be shortened for good behavior, like I do every day. There will be terms and conditions of probation, and there are 35 terms and conditions of probation here. Almost all of them are requirements I have to follow, and he has to follow. So everybody goes, 35, my God. No, we're not telling you to, you got to run laps, or you got to swim the ocean. This is commit no crimes, avoid injurious and vicious habits, don't associate with disreputable people. You can see what I'm talking about. These are things, do we really have to tell you to do this? But it's part of this, so that you can be the best person you can be. Don't use and possess any illegal drugs, et cetera, et cetera. One of the terms and conditions of probation, though, I'm going to require you to complete the defensive driving class and pay all associated costs. That will help you with your insurance that's going to go up because of this. All right. Do you know, and you're fined $500. All right. You understand what's happened today, sir?
Yes.
All right. Do well. Okay. Please see him and you'll begin probation.
Thank you, Jeff.
Yes, sir.
You
have something else? Okay. Tell me when you're ready.
I'm fixing to get a bullet. It'll be a plea. If I'm Chef Therio, it'll be a plea.
Okay.
But it's going to be for now. I've got here. This week, I've got a case. I received the discovery about 2 weeks ago. The allegation was about $17,000. I'm waiting on some base records. And so we're going to get that case disposed of one way or the other. I just need to look at these records.
Yes, sir. So what today you got? How many?
I've got Miss Lee. I've got 2 cases on Mr. Figueroa. I've got Norville.
Which ones of these are we going to be disposing today?
Figueroa.
Okay.
And we're working on the paperwork on that.
Okay, let me know when that, and then we can release the other ones for a continuance. Hey, John, you got Rachel Langham. Is that Rachel Langham? Come from? Nice. One case, right?
Yes.
All right, 26 CR 643. This is a 3rd-degree felony with credit or debit card use.
Your Honor, we can probably save a little time here. She has hired Mr. Himmler. So that changed anything you're going to do, but.
Okay. Yeah, no, you can hire anybody you want. But just get somebody in the game. Okay. Yeah, this is
a neat initiative.
Yeah, I'm not. So my blood pressure is not up on this one. This was handed down by the grand jury in April.
Yes.
April 15th, though. I don't know if that's good or bad luck for you. Income tax day.
Yes.
You're looking at, though, this is a 3rd-degree felony. If convicted, you're looking at up to 10 years in prison. So it's got to be treated seriously, and all cases are treated seriously, especially when a victim alleged in the indictment is someone who is vulnerable, like an elderly individual, such as what the grand jury has alleged you have done. This probable cause states you appropriated illegally a debit card while she was in the hospital. and used it to take money from her checking account. It was like $320. And the real problem here with you is there's a video of all of this happening at the Gulf Credit Union. And the lady was 70 years of age. That didn't play well to jurors, a vulnerable victim. So you got to deal with this responsibly. I don't see any criminal history, but
I deferred adjudicated probation.
criminal convictions.
Yeah.
That's what people make mistakes and deferred. You're not convicted, and that's what is important here. If you're convicted, you've got a record, and unless it's been purged, which is rarely done, then it's carried. You carried that around.
Misdemeanor charge.
It's a misdemeanor. It was a misdemeanor.
Alcohol.
I mean, if it was deferred, you're not.
That's a thing.
All persons are presumed innocent unless found guilty.
She's
You weren't
actually
found-
served out 2 different deferred probations, Judge.
Yeah, so still, that's not used against her. I mean, for purposes of sentencing. On this one. How much time?
She's hired Mr. Kimler, but I say at least give 4 weeks, for Mr. Kimler, to get in and take care of it.
Okay, it's reset 4 weeks for an announcement.
Yes, reset.
Cameron Nichols.
Nichols?
He told me he felt his car was second.
26 CR 928 is now called the State of Texas versus Cameron Nichols. Is that you? With Mr. West here, your attorney and the state's attorney is going to be here, and that's going to be sure who it is. And it this alleges that you committed the 3rd-degree felony of obstruction or retaliation, that you intentionally or knowingly threatened to harm another person with assault in retaliation for or on account of them acting as a public servant, namely a Loma police officer. This. Okay. Apparently, the patrolling officer observed a silver Honda. I guess you were in that with an expired registration. And they stopped you. And then you were placed under arrest for multiple city warrants. As they were investigating, according to this, you told the officer, "I'll slap the shit out of y'all when y'all take the cuffs off." Nice. How'd that work out? They just didn't let you go, did they? Might as well say, "Please arrest me now." Take me. I mean, that's about as foolish of a statement as I've heard. And I've only been doing this for 45 years. Speaking you were speaking to multiple officers. Well, they decided that that was a crime of intentionally or knowingly threatening to harm another who were operating in public servant positions, the officer, and you were taken to jail and booked. The only thing to explain that is you must have been intoxicated, out of your mind or something, because who would say that? What do you think's going to happen when you see? You think they're going to shake your hand and give you an award for politeness? You're going to get arrested by threatening an officer who's conducting an investigation. And that's why you're looking at up to 10 years in prison if convicted. Okay. John, yes.
Initial appearance, Your Honor, if we can get about 4 weeks or, I don't know when my next, I know that's a vacation.
4 weeks, you got it.
4 or 5 weeks, whatever my next, Ellie knows my doctor. She knows my schedule. So whenever I'm back.
Uh-oh.
The kids.
It's the kids.
We weren't saving children.
Mm-hmm. Yeah, JD's good. What does he have a criminal history? I don't know.
He's got an arrest for something else. I don't know whatever happened to it, but.
No,
I don't think he's had him.
what's the UMHB? What is that? Sir?
University of Mary Hardin Baylor.
Oh, okay.
University of
Yeah.
Mary.
Okay. I get a reset in 4 weeks and, sir, be polite, whether you like to be stopped or not. It's not funny. I mean, you're looking at 10 years. What are you laughing about? It's 10 years in prison is serious. It does, you know, and everybody makes a mistake, and all of us get stopped for some reason by the police over our lifespan for something, speeding or something. But that isn't the way to handle it. By getting all that was a ticket at the worst, and then they let you go, and now here you are looking at 10 years in prison. You got to understand, this wasn't a wise idea. If all of this is true, here you are. You're having. It's going to cost too. It's going to cost you money, plus time.
Over there, I'll meet you right outside. Okay.
Cheyenne Courtley. Please. I'm looking at 2 cases, huh, John?
So I'll give a computer confirm that.
Well, it was real good in math. I'm counting 2. Are you the Miss Courtley?
Yes.
Yeah. And John West is your attorney, right? How you doing with your hair? Okay. Okay. Good. Well, these are serious, as you know. In each of these cases, you were charged with 2nd-degree felonies of aggravated assault with a deadly weapon on or about April 14th, 2026, Jefferson County, Texas, by threatening others with imminent bodily injury by using or exhibiting a deadly weapon, namely an automobile that in misuse is certainly capable of causing serious bodily injury or death. I'm sure nothing. It says that there were 2 vehicles involved in here, according to the probable cause affidavit. The victims here advised the police that you intentionally struck their vehicle from the passenger side several times until their vehicle went into a ditch, and 2 people were still inside the vehicle. And then this says one of the people in the car fled. Okay. You were arrested for aggravated assault, family violence, Mirandized, and you told the police after the Miranda warning, you voluntarily stated you were operating the vehicle following the victims and intentionally struck his vehicle. I don't know. Well, these are serious things. I mean, that's a 4,000-pound missile that can do a lot of damage. 4,000-pound metal missile. And that's why vehicles have to be operated responsibly. So in each of these cases, you're looking at up to 20 years in prison, which is 40 years in prison. So it's serious. What are we going to do today?
Your Honor, this is an initial from getting, I feel the full filings where my next.
4 weeks. You got it? And again, these are 2 cases, Ms. Portley, so deal with this responsibly here. I've got Taylor Neville. Who's who's your attorney?
Sorry, I think we got stopped.
Is that Miss Norville?
Taylor is where? I think he went to sign someone else up.
Good. Matt. You ready, Jennifer?
Yeah.
So we're ready, we're ready to play, right? So I'm gonna start.
Brent, you ready on this one?
Ms. Neville, yes, sir.
Right here. Hold them back right. You can write a card.
I didn't sign. 25 CR 1417 is now called the state of Texas versus Taylor Neville. That's you.
Yes, sir.
With Mr. Turkey, your attorney and the state's attorney does the defendant waive a formal reading of the indictment and the arraignment here. And we proceed in summary.
Yes, Judge.
In summary, this indictment alleges that on or about August 4th, 2025 in Jefferson County, Texas, you committed the state jail felony of, let's see. It says injury to a child and by criminal negligence causing bodily injury to a disabled individual by leaving the complainant in a locked, unattended van in high heat without supervision and proper medical care.
It's more than proper.
It's more than proper.
It's proper.
Yeah, there's a misspelling in a word here.
We'll abandon the other EI.
Okay, so the severely disabled patient who was left in the car alone in the hot vehicle for about 5 hours. Once the patient was discovered, his recorded core temperature was 107 degrees Fahrenheit. My God. I mean, that can lead to death. Anything over 98.6 is feverish. And suffered from heat stroke, seizures, dehydration, acute respiratory failure, and other side effects. We're fortunate here, this person didn't die. What was your responsibility to this person?
She was to transport. She drove the van.
Drove the van from where to where?
From
what
his-
purpose?
From Tayshaun to the main office.
For treatment, day treatment. From his home, basically his home to a treatment.
To a medical facility for treatment? Well, how'd this happen? I mean, you just walked off?
No.
You stopped the car? Well, how did this happen? This doesn't make any sense.
There were a lot of omissions by a lot of different people, and Mrs. Neville was kind of the one at the crux. She picked up someone that she had never picked up before. She got reassigned that morning to a new home. She didn't know the conditions of the people that she was transporting. She didn't see the gentleman in the back when she did the move.
Say that again? No, that last sentence? She failed to see what? Someone in the back of the van?
Yes, sir. He may have been slumped down or something at the back of a van. Which it's like,
well, how did he get in the van?
The home that he lives loaded him. She did not load him.
What is she? Okay, they load.
She's the driver.
I know, but what's she doing with her while they are loading into her van she's driving?
I mean, maybe
Are you doing laps at a bar? What? We don't know. Okay.
She said she's sitting in the vehicle.
Sitting.
While they load, yeah.
Yeah, I'm just.
All right. Well, we're lucky somebody didn't die. And someone guilty of this offense, which is a state jail felony, if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine can be assessed up to $10,000. Do you understand?
Yes.
What are we doing today?
Pleading five.
An agreement has been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation for up to 5 years. There will be then terms and conditions of probation, which are normal and customary for this type of offense. Is there anything special we need to be adding here in light of her position of responsibility to others?
Not that I'm aware of,
Do you
Judge.
still have a
don't.
job doing this?
I got a job. I work at fast food.
Well,
She's not a job.
Not a
Not
job.
job.
She works at Popeyes. That's what he was asking.
Oh, okay. No.
She does not have them.
Okay. No, you
I believe you
Can't
fired.
harm
She was fired from
you
the job.
can't harm the fried chicken.
Fried chicken's good. Judge. Popeyes is the best in town.
I can tell. You have a
Wow.
partiality to it.
Wow. On YouTube, no less. Call me out.
I'm just kidding you. You're a renowned
I already knew
athlete.
that, Judge. When I said, "Look at
You're a
that."
renowned athlete. We all know it. Nobody. Although Judge Walker over there looks like he's been working out a little more than
He's
you
fit.
lately.
He's filming.
Yeah.
He's probably.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1.
Yes, sir.
Did you sign this?
Yes, sir.
Discuss this with your attorney. Is everything true and correct here?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, and it is freely and voluntarily made. You know what you've been charged with? The indictment's been read to you, brother. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, for the record for all purposes. Pre-sentence report is waived here.
Yes.
I'm going to follow this agreement, if nothing further, and find that, Ms. Neville, you are pleading guilty here to this state jail felony voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to find you guilty so long as you follow these terms and conditions of probation. You will be placed on what's called deferred or unadjudicated probation for 5 years. Please follow these conditions. If you fail, your probation could be revoked, you could be found guilty and then sentenced up to 2 years in prison. Most importantly, whatever you're going to be doing as far as taking care of others, you know, you've got responsibilities for their lives and well-being if you're taking care of others as well as yourself. So this was a fortunate thing that this elderly person was did not pass. I mean, this happens. The 107 degrees core temperature in your body is life-threatening. How old was this person?
I'm not sure. 20s, I believe.
Doesn't say.
I mean, that's speculation.
But it was a disabled person, was it? You gotta take, in your job, when you're taking care of people like that, you gotta be very careful. Their lives are in your hands. Please see the probation officer. That is on.
Mr. Figueroa? Are you guys here?
It's TCF Live, episode number 328 on this fine Wednesday. Sun is shining and the birds are not on fire yet outside the TCF bunker, but we're headed that way today, so that should be a whole bundle of joy once we get there. Let's do this. We'll stay in Texas, but this channel's promise of 9 to 11% more, Judge Boyd. Let's go there.
Okay. Well, this is what we're going to do, okay? Because one, I don't want to send you out into the world where you won't be successful, okay? So what we're going to do is, felony drug court said they're willing to speak with you and counsel. When they interview her, if you could be present, because I think you have more of a relationship with her where you can make sure that they're asking the questions in such a way that it's easier for her. So we're going to do a referral today. They will be able to see you because it's Wednesday. Vashawn, can you maybe see if they are willing to see her maybe this week if possible?
This week I could do Friday. Judge, I would not be able to do tomorrow.
Okay. All right. So see if they're maybe able to see her Friday. And actually, the person that I was able to speak to, that's the person who attempted to do an interview with her before. So they sort of have the basics. So we're going to try to get that done this week, and we'll bring her back next week. And so hopefully we'll have everything in place for you, okay?
So where will I be going?
Well, felony drug court, and they will help you with housing. They will help you.
I can go back to Haven.
Well, see, Haven for Hope is great, but I want to make sure that you have the resources that you need. With felony drug court, they will actually have case managers and someone to work with you on a daily basis, okay?
What about the settlement or cost point?
Well, I will tell you, felony drug court has access to those programs as well. So it's best that a professional see what program is best for you, okay? Because I don't want to set you up for failure.
Okay.
All right. And then my understanding from speaking with your attorney and speaking with the state, if you're accepted in felony drug court, then the motion to revoke will be taken care of to your benefit, okay?
Okay, so I'll be able to go home next week?
You're going to be transferred to felony drug court, and felony drug court will make those decisions, okay?
Okay.
All right. So what I'm going to do is I'm going to sign the referral for you to be interviewed, and counsel, Ms. Abrams will let them know that you're available on Friday.
So Judge, they aren't able to do it on Friday because they do have to work on Friday, but they are able to do it first thing on that.
Okay.
Probation to the
If not, I'll make it work.
Okay. All right. So they're going to interview you on Monday.
Will that be here, Judge, in your court?
No, their offices, are near the Bexar County Jail.
Okay.
I'll give you the address.
Okay. And so what we'll do is they're going to see you on Monday, and counsel will recall it for Tuesday. I'll put her on the docket for Tuesday. But if you already have the information on Monday, we can take care of it on Monday.
Okay.
Okay?
So I'll be able to go home if he just asks for me to go home Monday.
Well, Monday, you're going to have an interview with the people at felony drug court. And if they accept you, which I think they probably will, then we'll probably be able to resolve your matter here on Monday afternoon, counsel, or you can just call Megan and let her know what the outcome is.
Yeah.
But I want to put you on the docket for Tuesday to make sure that you're not lost in the system. But your case will probably be resolved by Monday.
We'll have more answers on Monday or Tuesday and should know what's going to happen and where you're going to go.
Okay, so I'll be able to go home.
Maybe you'll be able to go, hopefully somewhere in about 4 or 5 days, we'll know where. We have a
So
better idea.
I'll be able to go home next week.
Well, right now, I don't know about home, but we'll have a place for you to stay. You mainly want a place where you can go to stay, right? Whether
Yeah.
Sands Ministries, Haven for Hope, Cross Point, you want a place where you can go, right? A place
Yeah.
of your own. That's what we're trying to work on. Okay? We should have some answers next week,
So I'll be able to go home soon as I finish this week.
possibly.
Okay,
Okay?
okay.
All right. So I've already signed the referral for them to interview you. And counsel, Norma, put this back on July 14th.
Yep.
And so, as I said before, we'll probably be able to take care of this by Monday, okay?
So when will I be able to go home?
You know what? Felony drug court will make that decision. So this is what I want you to do when you're interviewed by felony drug court. You can ask them that question and they'll be able to tell you, okay?
Okay.
All right, thank you so much.
Okay.
Alrighty, friends, entering hour number 3 of TCF Live this morning. Nice to have you all here again with me. Very much appreciated. Let's head east to Louisiana. We'll check in with the board where it looks like they're going to talk to somebody through a set of bars. So I'm just going to call it ahead of time and say denied, but let's see.
Francis Abbott.
Okay, my name is Pete Freeman. I will be the acting chair today. Joining me on Zoom is Ms. Cheryl Renata and Mr. Steve Prater. Our first hearing today will be on Jacob Kelly. Okay. Kelly, can you hear me?
He said yes, he can hear you.
Okay, good. State your name and DOC number.
My name is Jacob James Kelly. I have a DOC number 1.
Okay, let's see, about 461009. Sound right?
Nah, what's up with that?
What's your date of birth?
Oh, no probation or parole.
You're not on probation or parole?
Fuck no.
Okay, where's your lawyer?
My lawyer is African standing, motherfucker.
Okay.
Man, suck my dick, man. Get the fuck out of here.
Okay, I think we have. Do you want to continue or you want? I was going to vote.
Oh, the attorney's on. Oh, we're
Okay.
Get the attorney.
Yeah, we're going to do it with the attorney. Thank you, Lafayette. Would you please state your name, ma'am?
I just moved away because he's throwing water.
Yes, ma'am. That's okay. We're going to continue here with his attorney. So thank you all for coming.
Thank you. Thank y'all.
Where's the attorney?
The attorney. See the.
Good morning. Mr. Dieter Gidman, would you pronounce your name, sir, for the record?
Yes, sir. Attorney Dieter Gidman.
Okay, we didn't have much success with your client, but we did get his name and we're on the record. So we're going to continue with this hearing. Mr. Prater?
We're kind of at a loss on Mr. Kelly, Jacoby Kelly. Do you have anything to say since you're his attorney? Would you kind of fill us in on what's going on, or?
I haven't had any success talking to Jacoby, right? He's been very combative with me. So I'm really kind of like you, I'm kind of stuck. I don't know what to do, right, with him.
Okay. Yes, sir. I see. Let me ask you this, if you have anything. At one point, it said in there, ICE detainer. Do you know it? It doesn't make sense, but.
Yeah, I don't know anything about that. That's the first I'm hearing about it.
Okay. I don't think there would be, and I don't think it has anything. I wanted to ask you about that. He's refused to sign anything. He's not coherent. Okay, we're here to talk about a revocation hearing for him. And he's charged with having violated one particular condition of his parole, and that's the simple burglary and simple criminal damage to property. He was billed on 5/26 and arraigned on 6/26 of 2026, and it's his second theft in 2 years. My fear is that if we let him out in the condition that he's in, he's going to either hurt himself, hurt someone else, or be hurt by someone else while attempting to hurt them, or while attempting to burglarize something or to steal something. So my vote this morning is that we revoke his parole because of violation of condition 4, which is the simple burglary and the simple criminal damage to property. And the DLC do a full evaluation on criminal evaluation, and maybe they can give us some recommendations or some insight.
Okay, Ms. Renata?
Yes, I agree with Mr. Prater. My vote is to revoke for the violation, probable cause found for violation of condition number 4, and ask that he be moved to DOC for mental health evaluation and treatment.
Okay, and my vote is also the same, that he be moved to DOC for evaluation and to get treatment. I think there's a preponderance of evidence here to show that he has violated his parole. So that'll be it at Lafayette Parish at 8:59. Thank you, sir.
Absolutely. Thank you all.
So he was a charmer, huh? I swear to you, I had no idea. I hadn't watched this ahead, so no idea what we were stepping into. But, well, the ICE detainer thing is probably a paperwork error. I would like to believe this. I would like to believe that this man is so offensive to everybody's senses that Republicans and Democrats alike came together on this one issue and said, let's throw him the hell out of this country. See, we can be united. That's all I'm saying. All right. Back to Judge Boyd.
That's all right.
Yeah.
I just want to let you know, hey, I respect, you know, I've been hearing a lot of good things that you're trying to help a lot of people, and you got respect for me for that. I just appreciate what you're trying to do, you know what I'm saying? You're trying to help people instead of just.
Oh, hey, I try to do what is right.
And then, my bad, one more thing is, you had reset it for trial. I'm really not trying to take it to trial, you know, I got caught red-handed.
No. So here's the thing.
My bad, you know what I'm saying? But I'm just saying, you know, all right, cool. Yeah.
All right, so here's the thing. I am legally not allowed to talk to you whatever agreement or something you've worked out with the state. What I can tell you is your attorney is not going to be here today. This is a possession less than a gram case. So one, you can wait for your attorney. I don't know when he will be back.
Monday.
So he'll be back on Monday, or if you are asking for another attorney to be appointed to you, an attorney can be appointed to you, and we can take care of your matter today if that's the agreement you've had with the state.
Oh, no, he's just trying to reset it, and then you had said reset the trial, and I was like, but yeah, no, he's good. Yes, ma'am.
All right, Norma, we're gonna call Mr. Belzon for Monday. All right, is there anything else?
Oh, man.
All right, we'll see you back on the 13th.
Thank you.
Thank you.
I think that was all correct.
Yeah,
Okay.
thank you, you're so awesome.
All right, friends, let's go back to Judge Stevens, new contestant there.
We're going to be entering a plea on 731, and then 730 is to be dismissed.
Yes, sir, in a misdemeanor.
Sir?
In a misdemeanor case that I've got nothing to do there.
Okay, but that's not before me.
No,
Oh, that's
it's not.
okay. So on this 730, no, everybody okay? All right. Remember, everybody, it's 2 on the mouth, 5 on the chest. That's correct. If something bad happens. All right. What happened on this one? This 730, I guess that's been worked out.
It's of the same fact and circumstances, Judge.
The complainant is okay with all this, huh?
Yes, sir.
Okay, all right. It's different set of ultimate circumstances, I guess, of this one versus the other one. Because he's pleading to one, but they're 2 different victims, but the victim is okay having this case dismissed.
Judge, it's the same facts, circumstances, two different officers.
Right.
So,
But the officer is okay.
yes, sir.
Who's getting, because, you know, sometimes they go, why wouldn't somebody held responsible for my injuries or something? But that's all been resolved.
Yes, sir.
All right. Put that one aside. 25 CR 731 is called you were Juan Jesus Figueroa,
Yes, sir.
and you were here with your attorney. Mr. Walker, the state's attorney does. The defendant waive a formal reading of the indictment and arraignment here. Can we proceed in summary?
He does.
In summary, Mr. Figueroa, this states that on or about April 29th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer, a Groves police officer. Do you understand what you're charged with here?
Yes.
See your address here in this indictment. I grew up about 5 houses down from there on that street.
Did you?
Yeah, right off of Lane 32nd. This, if convicted, this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? It's a serious crime, second-degree felony.
Yes, sir.
An agreement has been reached where you would be pleading guilty, but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in. And this other case, 25 CR 730, shall be dismissed, and also a 25 CR 1432. Is that in our court? It's a misdemeanor. You know what I'm going to do? I'm going to fix that. See, y'all were struggling at this getting that 0 in there.
That was me, Judge.
And I'm gonna take care of it. See if there's a question about it. Also, you'd be fined $500. There would be terms and conditions of probation, which are normal and customary. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of what this alleges? Show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney? Are the contents all true and correct? Yes. State's Exhibit 1 tendered into evidence without objection admitted. You've probably heard this one before. I've said this over and over again, but in every case, I must say that this, among other things, states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand and know what you're charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your constitutional rights of a right to trial by jury and presentation of witnesses on your behalf, and you are guilty of this crime and any lesser included offenses, and you were totally satisfied with the representation provided by your lawyer. All of this is true. It states at the bottom, so help you God. States Exhibit 1 made a part of the record for all purposes. Pre-sentence report is wait.
260755.
Yes.
No objection.
Okay. Now, if nothing further, I'm going to follow this agreement then and find Mr. Figueroa, you are pleading guilty here voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this second-degree felony of assault on a peace officer. However, I am going to defer or postpone any kind of appeal so long as you follow these terms and conditions of probation. And if you fail, your probation could be revoked and could be sentenced up to 20 years in prison. We don't even want to think of that. but you're gonna be on probation for 10 years, and it will be shortened for good behavior to a third of that, 3 1/3. If you do that. Make sure you follow these terms. And I'm sending this to the probation office. And one of the other conditions of probation, you're going to complete an anger management program and be required to pay all associated costs, which are normal and customary for this type of an offense. All right, anything else to add here? Yeah, I think there's this dismissal will be coming.
I've submitted it, Judge.
And I will sign that. And there it is.
Thank you, Judge.
Thank you. Yes. Was there a fine on that?
Should have been a $500 fine. There should have been a $500 fine.
Lane, on that, is there a fine on $500?
$500.
Okay,
Yeah.
and the court also will assess a fine as agreed upon by the parties to an amount of $500.
Thanks.
And 25 BR730. That pending case on Mr. Figueroa is hereby dismissed. How you been there? Got a moment here? Yeah. That's
What did we say on down there?
That we're working
we
on
have
that
to
one.
save our children.
Yeah, we're working.
Kids in here for a little while.
They rotate.
I guess they got scared and left, huh?
They have to rotate through the floor. We had originally told them we're gonna do a tryout, so I think they're also far. That's yours. Okay, so we put these people in prison for pushing the if we still know.
Rania Beau Boudreaux. That you know?
Yes.
Actually, we have 2 cases here, right?
My understanding is there may be some misdemeanors coming forward.
All right, just so you know. Before the court are 2 indictments here with your name on it. 26 CR 747 and 748. In each of these cases, you are charged with the state jail felonies of credit or debit card abuse. Each of these cases carry with it up to 2 years in the state jail. So you're looking at up to 4 years in a prison type facility if convicted. And
Sign this. Yes, you. But my lawyer's file. He hasn't been given.
Well, you do this thing long enough, you see it all. You're charged with these 2 state jail felonies of credit or debit card abuse. The question I had, of course, was how in the world do you get access to somebody's credit card and then use them? Well, you're working at McDonald's. And they give you their credit card to pay, and then you take photographs of their cards and then misuse them later. That's low. That's low. Shame on you for that. It hurts McDonald's because now people will have questions about the security of their monies. But when they give that to you to pay, they're assuming that you're going to be trustworthy enough not to misuse it, but not you. You didn't do it on one case. You did it at least twice with 2 different people. It's better. I'm sorry, I hope McDonald's has changed the way they do things, but when you can't trust people like that, like this, it puts a hamper on just the way we make purchases. But people give their credit cards to others all the time to make payments. And we trust that someone like you is not going to take a photograph of it and then misuse it. I guess McDonald's got rid of you. They fired you when they found out. It's the least of your problems. And now you're looking at up to 4 years in a prison-like facility. This is terrible. This kind of thing, because everybody uses credit cards on it, literally, and we have to trust that it's not going to be misused by people like you.
Yes.
Shame.
All
right, that's my speech.
As it turns out, Judge, she was on misdemeanor probation at the time.
For what?
That was for evading arrest or detention. There's an administrative hearing that's approved a motion to revoke her probation that has not been filed yet. We were trying to resolve all 3 of those cases when I looked in our system and saw that we received 2 more misdemeanors on her that were alleged to have been committed on June 27th. So
this year?
Yes, sir. So I haven't had a chance to look at those, and that of course is gonna.
You mean she is allegedly committing crimes after she was indicted?
That's what it appears to be. And I know how sensitive the court is to that, as I am too, but I have not had an opportunity to look at that. Like I said, they were received yesterday. So, and it may be that we refuse those. There's no telling. I don't know what the details are on there, but I am concerned.
But she's out and about.
Correct.
No, I can revoke her bond and stick her in jail until this all gets finalized, which is probably in the best interest of at least 250,000 people in Jefferson County who trust that their credit card won't be misused. But anyway, that's but she's out and about.
I have concerns about flight because now we've told her in the courtroom about a warrant that's coming and 2 additional cases.
Well, that'd be another crime.
Yes, sir.
And y'all always catch them.
Yes, sir.
But anyway, yeah, I don't have anything before me other than this until y'all do a formal charge or get me a complaint. And then we have a hearing on this. Then I'm not changing the bond, but I will change the bond if you're committing crimes while on this court's bond. Taking that I'm administrating in your cases. If you've got pending cases and you commit crimes, then your bonds will skyrocket up. I'm not going to let you continue to harm people after you realize that we're holding you accountable and this is serious. And if you can't figure out that means stop committing crimes, then you're a danger to the community.
I'll look into those matters today.
Yeah, I don't trust her at all. I mean, this is serious. The poor people, and here's the deal: their credit is ruined. their credit. They've got to fix their credit now. You've got problems with their credit card company, with their credit worthiness that most people work hard to prevent from being bad so that they can continue to have access to credit if they need it. People like you foul that all that good work that they're trying to do to keep their credit worthiness from being blemished. You come up and foul it all up, and then they're the ones having to pay for it. Shame on you. Thou shalt not steal. You heard that one before? It's a kind of an important rule. One of the top 10, as I understand. Shame on you. All right, let me know, because I don't want her out.
Yes, sir. I know.
Being a harm to everybody else. And what are you're asking for 4 weeks?
Yes, sir.
All right.
Just can we keep a shorter leash so that I can check into this? Maybe a week or 2 instead of 4.
Well, let's review it in 2 weeks. Okay.
What day is it now?
Sir?
22nd.
You're
here next week.
Don't commit more crimes. I don't know why I have to say that. Lloyd Denman?
Yes, sir. I just received an offer on that one.
What are you gonna do?
Need to resend it so he and I can visit, because it's
Where's Mr. Denman?
he's the showman of the blue shirt judge.
Okay. He's struggling. Is he okay?
Just never.
Come forward. Does he need some help? Yeah, come on up. Yeah.
Can he have assistance?
Yes. Yes. Come on up.
What's not on there? No, I didn't.
I'd be fine with you. Right here, sir. It's all my words.
That's for.
We don't sell places.
So this happened on March. Was that a couple of months ago? A few months ago?
Yes.
You are Lloyd DeWitt Denman?
Sure.
All right. And Mr. Denman, you are charged here in this indictment. And there's this indictment. There it is right there. Handed up by the grand jury. And it states that you committed the 2nd-degree felony of aggravated assault with a deadly weapon. And I'm reading this. Apparently you were at St. Elizabeth Hospital and the police were dispatched due to a patient stabbing a nurse. And it looks like that according to this probable cause affidavit, a nurse could see you getting out of your hospital bed and the nurse walked in the room to check on you. Then this states you raised your right hand and stabbed her with a large pocket knife above her left breast, which is the side where the heart is located, causing pain and a puncture wound due to Mr. Denman stabbing the nurse with a knife, causing serious bodily injury. You were charged with this aggravated assault. Do you remember this event?
Very little.
Okay. And I'm looking at, you are, let's see, 85? Is that right? 85 years of age?
Yeah,
Okay. What were you in the hospital for?
hallucination, nations.
Hallucinations?
Yeah,
Okay. Have you been in the hospital before for that?
yes,
One other time? Okay.
Several years ago.
Are you taking medication for that?
Yes.
What's the diagnosis? Is it Alzheimer's or
It
something?
is not. So he had hallucinations.
What, that's not normal.
Correct. We took him to the hospital with hallucinations. What we figured out is he has a tumor that's on his parathyroid gland that he actually has surgery to be removed.
And that causes it? That's what they say?
Yeah.
All right. Was he in the hospital getting treatment for that?
He was originally at Jasmine Memorial. They couldn't treat him. They transferred him to Beaumont, and he had been there just a few hours. So he had not.
Okay, what are they doing about the thyroid?
We're having surgery on the 27th of the month.
Okay, all right. All right, let's, he's charged with something that's could result in a 20-year prison sentence. So it's very serious. Has he ever been in any criminal trouble before?
He's never been arrested ever.
Never been arrested. Okay. All right. Are y'all still up in Newton?
He lives there. With my mom.
Alone?
No, with my mom.
Okay. All right. So what do we do?
Need to reset this one. This is the initial setting. I need to get some information. Obviously, I need to look into his medical condition. Get some information on that.
Obviously, though, if he's alleged to have stabbed a nurse who's trying to treat him, what's the danger to others? Is there something that we need to deal with?
I can't speak.
I mean, well, shame on my watch. If something bad happens next time, huh? He's at a hospital and he's stabbing a nurse, according to this, for maybe medical reasons. But what are we doing to prevent this from happening again?
He won't go to say any.
Sir?
He won't go to say any.
No, but there's 4 billion people on the planet, 7 billion on the planet.
Judge, I don't know what his mobility status is, but we can place him under house arrest except for medical and necessities.
Yeah, what we got to do is control the potential harm to others.
He's on medication currently.
I know. Was he on medication at the time?
He was not. They had not found the cause. After he left St. Elizabeth, we took him to Houston Methodist.
Tell me about the medication and what it's supposed to do.
So where the tumor is, it causes his body to make more calcium than it needs to make.
Okay, what is that? How does that result in harm to others?
So the calcium made him have the hallucinations.
That's fair.
So when we took him to Methodist, that's what they diagnosed him with. He's been on medication to prevent the calcium from being too high until he has the surgery to remove the tumor.
Okay, and that's what the medical people say. It was high calcium.
Correct.
Caused him to
hallucinate.
And what they're doing to treat him is going to stabilize the calcium.
Correct.
Which is, they say in their medical expertise, will prevent him from having a situation like this.
Yes.
Again.
Yes, sir.
Everybody agree with that? You do?
Yeah.
And you, ma'am? You're his daughter?
I'm his daughter. I'm also a registered nurse.
Okay. All right. How long have you been registered?
26 years.
Good for you. What states say about this?
Judge, we have been fully prosecuting. We've had a lot of assaults on nurses lately, so we're prosecuting every one of them to the hilt. This one's a prison time offer, unless he goes unagreed to you and tries to get probation.
What did you hear? Well, you've heard. I'm not going to insult you. You've heard. You're a smart guy.
Yes, sir.
She says that medically, what happened was this was a result of a calcium, some high calcium from a thyroid condition that resulted in him acting out of his mind, literally, and that they are treating it. And the doctor states that the thyroid condition that produced the high calcium is treated and he should not be a danger to others. So
Yes, sir. He also said he didn't remember much about it, but when you were talking about using a long pocket knife, he went like this. He was trying to show his lawyer it was only this big, so he remembers more than he's saying.
It's because he's had that pocket knife for generations and it belonged to somebody before him.
Judge.
Okay, it's not, I know it's not late, but here, no, the point is we still have to air this out. Sure. The state's got a right to be heard about any issues concerning security and eliminating the harm potential to others, and that's fair. I mean, that's what they do. That's what their oath is to see justice and also to protect and serve the community. And I want to make sure that that's being done on her. She's a registered nurse, and she's also not under oath here, but she's been a registered nurse for over 2 decades. And I have family members, registered nurses, so they take care of their business, especially if somebody's been an RN for that long. And from her point of view, it's, medical is a science. So
I understand that. I have absolutely no medical in front of me. I have what is in my file, and if the defense provides me with medical, I'll be sure to consider it and look at it.
Well, he's on bond, and what we're going to do is keep him on home confinement so he's not out and about and something bad happens until we can get this resolved.
Can I ask a question about that?
Except he can go to and from doctor.
Okay.
To and from doctor. Who does he live with?
He lives with my mother.
With your mom. Okay.
His doctor is in Houston.
All right.
So we'll go him there.
As long as your bondsman.
No, he's been retired for years.
Yeah, he needs to be in home confinement, but the bondsman needs to know whenever he leaves the home, except for out and about the yard. If he goes to and from the doctor, that's got to be in the most direct route possible so that there's not a problem later. He was out in San Antonio or something.
Okay.
And all this is restriction. These are normal restrictions that we make to freeze the situation so that there's not a problem that erupts while we are trying to dispose of this case in a fair way. Where else does he go?
He goes to my house to doctor's appointments. That's about it.
Okay, then for those purposes, he's going to be allowed, but to leave the home. But again, it's in the most direct route possible with chauffeur. And so the bondsman needs to know about those restrictions.
Whoever, he doesn't have GPS.
He doesn't have a GPS.
We're no GPS. Okay, I'll do a memo to them.
To get any more cumbersome for him than that.
No, I'm a trust that y'all can take care of it, but what we don't want is a problem that's subsequently occurs that's similar to this while we are waiting to get this disposed of, and then the headlines become who's to blame. And I would be the first suspect, and I'm not going to stick my neck out irresponsibly, but I think this can be under control under these terms and conditions. We generally put people under GPS, but if he's going to go somewhere, he's going to have to be taken by somebody.
Yes, he doesn't drive. Neither does my mom.
And it's going to be your mom or you.
Or one of my sisters.
Or one of your sisters. They need to know about the rules too. Okay. Let's just freeze the action and get this thing resolved, and then everybody move on with their lives without any further problems that just muddy up the water.
This is your reset list of YouTube.
Can you stand it for me?
Was that okay?
Yes, sir. I can't drive. I can't drive.
Tell you what, put an X right there for me, and then she can sign right by your X. Put it like this.
No, I don't sound very well.
That's fine.
It's okay.
What?
Good. And then you can sign it. You put his name. They're good. They're good.
When's the next resetting?
I'm gonna do the first month of October, so that hopefully.
He'll be back.
Surgery.
That's my.
We're gonna have him back in October, but
That's your.
we're gonna have him back in October, but we'll have to resolve that.
Yeah,
so that
we're gonna get the
that
medical
works with his
records.
medical needs.
I'll get with the state and figure something out.
Okay. Anything else? That is all on this. Thank you. Kimberly Free, please.
All right, friends, I need to speak. I see this from two different angles. My daughter is in healthcare. She works in a hospital, mostly in the emergency room. She is a respiratory therapist, so she's the one who's stuffing tubes down people's throats and stuff, trying to keep them alive. She deals with a lot of different patients, and she and I have talked about this type of scenario because she's seen it before, where people are combative and aggressive, and in her opinion, most of the time it's because they're out of their minds, because there's something very broken inside them. Here we've got an 85-year-old man who is having hallucinations, and the prosecuting attorney has said, well, we've got all this violence against nurses and we're just prosecuting every one of them to the hilt. That was his words. So he's like, our offer's going to be a jail offer. Really? For an 85-year-old man who's losing his effing mind, that is your solution? I'm sorry, that prosecuting attorney is an ass. And for the record, I hope that the nurse is okay, and I don't want anybody to come to harm. However, harm is a possibility in that job. I've talked again with my daughter about this sort of thing, and she's said it. It's part of the game. It's something that you have to accept could happen. Tell me where justice is going to be served by taking an 85-year-old man and putting him in prison. It makes no sense to me whatsoever. I'm not saying what he did was right, but I am saying from what we can see, he was most likely out of his mind, had no idea what he was doing, and this is stupid to me. Get the man the help he needs, get him the medical attention he needs, and if he needs soft restraints while he's in the hospital, you give him those. Quite honestly, if he was hallucinating and at all showing any kind of aggression, I'm surprised they didn't do it in the first place. It shocks me that he would have gotten that far without some kind of attention to that already. So, you know, you're going to say, well, you're blaming the victim. Maybe, maybe not. I don't know. But it sounds to me like somebody dropped the ball there, potentially, and could have avoided this by already having somebody restrained who's not well. I don't know. This one pisses me off. If you see it different, let me know in the chat. We're always open to discussion here, but this is not justice. This does not help anybody. And again, I'm sorry the nurse got hurt. I really am. But it is an unfortunate part of that job, is that you're going to deal with people who are out of their minds, and stuff can happen. You can do things to mitigate it. It doesn't sound like they did. Anyways, and by the way, I said I see it from both sides. The other side, you know, my daughter's a nurse. The other side, I spent a lot of years caring for a man who had also lost his mind via stroke. He was incredibly broken, and he was prone every now and then to acts of aggression because he was broken. Anyways, Lake County, Judge O'Donnell.
To the amended indictment, I have explained his constitutional rights to him. I believe he understands them. No promises or threats were made to induce him to change his plea, and I will acknowledge that there will be a joint recommendation to the court of a 40-month sentence, understanding that it is in the court's discretion. Thank you.
Mr. Harris, how old are you?
I'm 34.
How far did you go through school?
I graduated high school, and I went to trade school for mechanic.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Correct.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
I take Zoloft.
What do you take that for?
I have PTSD.
When did you take it?
Yesterday. in the morning. I take them every day at 8 o'clock in the morning. I didn't took none this morning.
Does that affect your ability to understand what's going on here?
No.
Did you get a copy of the indictment?
Yes.
And it's been outlined that you're going to plead guilty to count 1, trafficking of cocaine of felony 5, and the specification. And also count 3, trafficking of cocaine of felony 3, and the specifications there. Is that correct?
Yes, Your Honor.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Jordan some more, let me know, and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer for the appeal, one will be provided at no cost. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of the transcripts, they'd be given to you free of charge. You understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any question about any of these rights?
No, Your Honor.
You still want to plead guilty to these 2 charges?
Yes, Your Honor.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes, Your Honor.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, Your Honor.
In count 1, trafficking in cocaine is a felony 5, carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
Count 3, trafficking in cocaine is a felony 3, carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes, Your Honor.
If you plead guilty to the forfeiture specifications of both counts, you're voluntarily giving up the items listed. Do you understand that?
Yes, Your Honor.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 48 months and a maximum fine of $12,500. Do you understand that?
Yes, Your Honor.
Any question about the penalties?
No, Your Honor.
On count 3, there's a presumption that a prison sentence should be imposed by statute. You must overcome that presumption at the time of sentencing, or a prison sentence will be imposed. Do you understand that?
Yes, Your Honor.
Are you currently on post-release control to the parole authority?
No, Your Honor.
Do you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes, Your Honor.
You understand your felony conviction prevents you from owning or possessing a firearm?
Yes, Your Honor.
You understand if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority.
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Your Honor.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, Your Honor.
You could be placed on community control if you overcome the presumption for prison for up to 5 years, but if you violate, I could send you to prison for 48 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
Do you understand I don't have to follow a sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
You understand I don't have to follow a joint recommendation of the parties?
Yes, Your Honor.
Have you had enough time to talk to Mr. Jordan before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
Yes, Your Honor.
Have you been...
No, Your Honor. I'm sorry.
Are you knowingly and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No.
Ms. Alessi, if the case went to trial, what would the evidence show?
The evidence would show that on January 21st, 2026 in Lake County, Ohio, a controlled informant working with the Lake County Narcotics targeted the defendant as part of a drug investigation. The CI arranged to purchase an 8-ball of crack cocaine from the defendant in exchange for $160. That buy did take place at the Dollar General parking lot, and the defendant was identified as the person who sold the drugs. After a second controlled buy took place on the January 29th, Lake County Narcotics obtained a warrant for the defendant's arrest. The defendant was located on May 4th of 2026, where he was arrested on that outstanding warrant. During a search of his person, he was found to be in possession of multiple cell phones, $1,335 in U.S. currency, and during a search of the vehicle, he was found to be in possession of over 15 grams of cocaine, a Schedule II controlled substance. Thank you.
Thank you. Mr. Jordan, anything to add to those facts? No, Your Honor, those facts are correct. Mr. Harris, did you hear what Ms. Alessi said the facts would show if the case went to a trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
What is your plea to count 1, trafficking in cocaine, a felony 5?
Guilty.
What is your plea to the forfeiture specification?
Guilty.
What is your plea to count 3, trafficking in cocaine, a felony 3?
Guilty.
And what is your plea to each of these specifications?
Guilty.
Mr. Jordan? Approach.
The defendant and his attorney have signed a written plea of guilty here in open court. I've signed it as well. May I approach?
Yep. Mr. Harris, is this your signature on the written plea of guilty?
Yes.
Did you
Your
sign
Honor.
it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
And I'll accept the written plea of guilty. Defendant was present with Mr. Jordan, advised of all of his rights, being a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty. Find him guilty of count 1, trafficking in cocaine, a felony 5. Count 3, trafficking in cocaine, a felony 3, and the specifications on each count. I'll refer this for a pre-sentence report. August 20 at 8:30 will be the sentencing. The bond is revoked. Anything else, Ms. Alessi?
No, Your Honor. Thank you.
Jordan? Nothing further, Your Honor.
Alrighty, friends, a few more minutes left for today's episode of TCF Live. Let's go to Louisiana. We'll finish with the board one more time. Hopefully this person, he's not behind bars, so this should be more peaceful.
Parole board is called back to order. My name is Pete Freeman. I am the acting chair. Along with me on Zoom is Ms. Cheryl Renatza and Mr. Steve Prater. We're here now for the hearing on Bobby Williams. Mr. Williams, please state your name and DOC number for the record.
Bobby Williams, 422-427.
Okay, Mr. Williams, here to support you today, we have Ms. Hutchinson, your attorney. You want to introduce yourself for the record, Ms. Hutchinson?
Absolutely. Adrienne Hutchinson, attorney for the Louisiana Parole Project, here representing Mr. Bobby Williams.
Okay, then you'll have Mr. Kerry Myers from the Parole Project speaking on your behalf. Alexandria Rochelle, I hope that's right, sister.
Alfred.
Okay, will be speaking. Fred Sanders, a childhood friend, is here in support. Kristen Carter is here, your daughter. Alfred Rochelle, the father, will be speaking. Stacy Williams, wife, is here in support. Calvin Henderson is a friend in support. And Alejandra Angel, Parole Project, here in support. Chastity Acree, Parole Project, here in support. Stacy Williams, your wife, who will also be speaking. And Barbara Terrell, your son-in-law. Did I get everybody? Okay. All right. I'm going to read some information into record and then we'll get started. I've been assigned your case, Mr. Williams, so I'll be doing the interview. Mr. Williams, you're a third-class offender. Your parole eligibility date is 3/4/26. Your adjusted diminution of sentence date is 5/1/2040. And your full term date is 10/26/53. You're serving a total of 50 years for the charge of attempted second-degree murder. Does that sound correct, Mr. Williams?
Yes, sir.
Okay. All right, Mr. Williams, I want you to tell me, what did you do to get yourself put in prison? And tell us the whole thing. Now, we have everything. So tell us, what did you do to get yourself put there, and what you've done since you've been at it that should make us feel safe that you can go back into the community?
On the night of September 20th, 2004, my co-defendant, Ronald Banks, had called me and said that someone wanted to get 9 ounces of cocaine. And he asked me where I was, and I told him I was at my mother's house. He can come get me. So that night when he came, got me. We stopped at a store, and my other co-defendant, Adrian Minor, he had got in the car and he rode us to Bunker, Louisiana. We rode to Bunker, Louisiana. My co-defendant, by me not knowing the guys, my co-defendant stopped and he met his stepbrother in some apartments, and we went to his stepbrother's house where him and Mr. Patrick Green and his stepbrother, they all went inside the house to do the drug transaction. I stayed in the car, but I had got out the car that night when we drove all the way down there because we was in another parish. I got out to use the bathroom. And when I got out to use the bathroom, by the time they was coming out, Mr. Green, I started Mr. Green by being on the side of the house using the bathroom. And once I started him, me and him started arguing. And after we started arguing, we started fighting. And once we started, in the midst of us fighting, I shot him. I shot him one time. And then I ran away. Then I ran out after that.
That is correct. You did tell us the whole story. Okay. Now tell me what you've done that we should feel that you'll be safe in the community and no danger.
Mr. Freeman, I've taken multiple classes, and I knew I needed a moral compass to get myself together. I've taken substance abuse, I took an anger management twice, and I've taken thinking for a change and victim impact. And then my substance abuse, I learned about relapse prevention, because I had caught a write-up in 2015 for Mojo, and that's when my aunt died, and I tried to use that as a clutch for my drug addiction, because I know that I will forever be an addict. And then I really straightened myself out when my mother died. By me being at the barracks, I didn't help to facilitate AANA. And I knew that I was powerless over my addiction, and I knew that I had to turn my will and my life over to the care of God. And by me going to weekly classes, I had someone to talk to if it was something bothering me, or I even had a sponsor, that Mr. Bob, that comes off the street that supports our AANA. And I knew that I was trying to get myself totally correct and right. And I also took anger management twice, because Green's death, that was the cause of his death, for my anger. And I learned in there the power of pause. Because if I would have just paused and we just could have talked about it and got an understanding, that would have never happened that night. And I understand that when I took my last class that I just taken, Victim Impact, I learned that I left a lifelong ripple effect on his family, the pain that I caused his mother and his daughter. And I have found a strict plan to maintain my sobriety. I plan to go to classes 2 times a week. And what I have done some research, and I see that you can take classes online also. So if I'm at work offshore or working on the railroad, I can still attend meetings while I'm at work when I'm off. I set this plan down, and I learned to use I have learned now to use my support system. Correct. I have a wonderful wife. I have my dad, my sister, my daughter, my mother-in-law, and my 5 grandkids, because I am a grandfather, and I love those grandkids, and they make me smile every time I see them. And I truly hate that Mr. Green had to lose his life for me to get my life back together. And I thought about it every day at that sentencing, that I thought about his mother and the words that I was listening to the words that she was saying. And I could hear the pain in her voice and the hurt that I had taken her son. I seen his daughter was there too. And her birthday was coming up, and it was hard. And I know it's gonna be hard for her to know when she get older why her dad's not at her birthday, why her dad won't be at her graduation, different milestones in her life. And I'm truly sorry for that pain that I caused that family.
Okay. All right, let's get to some of your supporters, and we're going to hear from them. Ms. Hutchinson, I think you would like to go last.
Yes.
Correct. Okay. Okay, let's hear first from Mr. Kerry Myers of the Parole Project.
Good morning, Kerry Myers with Louisiana Parole Project, here on behalf of Bobby Williams. Now, we were here 2 years ago when Bobby had his hearing. We continued to support Bobby, to believe in Bobby. At Bobby's last hearing, this board commended him for the work he's done, his rehabilitative work, and obviously recognized that Bobby needed some more time. Here we are 2 years later. Bobby has continued to maintain an excellent conduct record. His job is at the airport, maintaining state police aviation equipment. That's a very trusted position. Bobby continues to apply his commitment to his sobriety by leading AA and NA meetings, and as you heard, has a plan to maintain his sobriety through a support system. Parole Project will assist with that support system upon his release. We'll also, after 22 years plus of incarceration, Parole Project obviously understands Bobby's needs. We will help him through that transition, not only just through the transitional housing program, where he'll learn skills such as financial management, technology, social norms. He'll have a mentor guiding him through this process. We'll also continue to work with Bobby throughout the year and maintain contact with Bobby to assist him through his transition. Not only that, Parole Project obviously understands that And it is our motto that once a client, always a client. Bobby will always have the support of Parole Project if needed. Again, Bobby has done, since his last hearing, he's completed multiple additional programming, self-help programming, thinking for a change. Bobby's an excellent candidate. This is a perfect example of how corrections does work. Bobby is now mature, focused, sober, and ready to come home. We would like this board to consider those factors and grant Bobby his parole today.
Thank you. We appreciate that. Okay. Okay, next we're going to hear from Miss Alexandria Rochelle.
We have Mr. Alfred.
Okay, they see they had her to speak, and I was just wondering.
No, it's his father.
That's what I just.
Mr. Alfred.
Okay, all right, Mr. Alfred.
First thing, good morning.
Good morning.
On behalf of my son, Bobby Williams, I've been in his life since he was 5 years of age. Through his lifetime, I played a role in his athletic ability. He participated in sports. I also got a chance to coach him 4 years of high school, both football and baseball. As a young man growing up, church-going young man, we know he directed himself in the direction he wanted to go, not the direction that his mom and I sensed in him going in. That's church-wise, playing-wise, friend-wise, love-wise, neighborhood-wise, because he was a neighborhood guy that everybody flocked to the house. We had to keep the kitchen closed a lot of time, because when they can't eat. We done a lot of cooking. But on behalf of me as his father, I want to say that Bobby has made a big change in his life. We followed him from the very first time of all this incident happened. We chased him up and down the highway, making sure we were present. His mom's not here. She's been, this coming September, be 3 years. But her thing to me and to him, that stay together, love one another, and do the best you can. And when the grandchild came into existence, that was a big difference for me. She tells me all the time, I'm the oldest and I'm the first. And that's Bobby's daughter. And I want to say to behalf of the Road Committee that Bobby's been a great guy to me. He's been a father figure to me. And I might be considered his stepfather, but I'm his father. The 5 years mean a lot in anybody's life. And I came a long way with him, and he came a long way with me. Because not only did he participate in sport, he participated in a lot of other things outside the community. You know, he was our outgoing guy. He was in the National Guard. He worked offshore. His dad would drive him 4.5 hours one way to make sure he got to his job and drove back to go to school to teach the next morning. So I've done a great thing for him because I know he saw some things in me and I saw some things in him. So I hope and pray that whatever's been done here today will be a great thing for him and society. And I know that he will make a great impact when he do come back to society, and he will be a great influence to other young men and other young people in the city of Allegheny itself. Those are my words today. Thank you.
Thank you, sir. Appreciate you coming. Okay, let's go to Miss Stacy Williams, his wife.
Morning.
Good morning.
I am Stacy, Bobby's wife. I have known Bobby since we were in high school. We dated as teenagers, but eventually our lives went in different directions after high school. I attended college for a couple of years before joining the United States Air Force. Today, I'm a 100% service-connected veteran, disabled veteran, and have proudly served as a nurse for over 21 years. Although life took us down separate paths for many years, God brought us back together. For more than 20 years, Bobby has lived with the consequences of his past decisions. Through all of those years, I have had the opportunity to witness the incredible man Bobby has become. Bobby is not the same man that entered prison over 2 decades ago. He is a changed man, remorseful for the pain and harm he caused. Instead of letting his incarceration define him, he chose to transform his life. During his incarceration, Bobby has completed numerous rehabilitative programs focused on personal growth, emotional healing, coping skills, and preparing for a successful return to society. He has also facilitated many of those programs and has encouraged other men to make positive changes in their lives. This shows that he has accepted responsibility for his past and his harmful actions, and now desires to help others avoid the mistakes he made. Over the years, I have watched Bobby become a loving, patient, compassionate, sincere man. We have a blended family with 2 sons and 2 daughters, 4 granddaughters, and a newborn grandson. I have created a beautiful home where Bobby can begin this next chapter in life. Bobby has a loving father, sister, niece, and nephew who has stood beside him throughout these years. My hope is that he will be able to come home, adjust to life outside of prison, together with our family, where he can be focused on being a grandfather to his 5 grandbabies and taking the necessary time to begin his footing with our help to ensure his long-term success and stability. We have a network of support focused on his continued success. My parents are both ministers who have dedicated years of service to working with our parish, jail, and reentry programs. Their guidance and experience will provide another layer of encouragement, accountability, and support as Bobby transitions back into the community. Our entire family is committed to helping him succeed. As a family, we have sought out programs in our area to help support Bobby's transition home, should he be granted. We've connected mobile crisis program for sobriety support, and although Bobby and I are married, we never have truly lived as husband and wife. And we recognize that building a life together after so many years apart will require patience, understanding, and commitment. We've already discussed participating in marriage counseling to help us adjust, strengthen our relationship, and build a healthy foundation for our future and our combined family. Thank you for your time.
Thank you. Thank you for your service. Okay, Captain, I'm looking at you and I think I skipped over you, so I'm gonna let the captain speak on him before I let you, Ms. Hutchinson. I'm sorry.
That's okay.
Go ahead, Cap.
Good morning. Good morning. It's all good, brother. Mr. Alfred said something about Bobby, and it kind of struck with me how proud he is of his grandkids. He lights up when he sees those kids, man. It's a beautiful thing. But 2 things I can say about Bobby is discipline and humility. I get to work usually about 4 a.m. every day. And by the time I'm here, Bobby's on the weight pile every day. He's consistent with the things that he does every single day. He goes to work, he mentors, he helps. Recently, we had one of his work partners have an accident, and Bobby took care of that brother until he could get back on his feet. He has a job like everybody else here, but on his off time, he and another brother weed eat the fence line of our entire facility. We got 1,700 acres, by the way, and they go after it on their off time. They volunteer, they help, they do whatever they can to make this place a success. I have no doubt in my mind that given the opportunity to be a part of society, then again, Bobby will be successful. He's got an amazing family, a great support system, and with the help of the parole project, I know he'll be able to reintegrate smoothly and peacefully. Thank you.
Thank you. Appreciate it. Okay, Ms. Hutchinson, now we'll let you close us out on the support side.
No problem. Thank you, board, for your time and consideration of Bobby in this case. As Kerry talked about earlier, Bobby was before this board 2 years ago. He received 1 vote to grant and 2 votes to deny. What stands out about that decision, however, is that Mr. Freeman, you and Mr. Prater both were extremely encouraging of Bobby at that hearing. Asking him not to get discouraged with the vote because he time y'all recognize that he would be able to come up in 2 more years and to continue to do the work and come back in 2 years to get him a little bit closer to the halfway mark of the the sentence. At that hearing, y'all discussed, that he had shown responsibility and then demonstrated genuine remorse. He had a good institutional record, and had done the necessary work to change his life. And so over the last 2 years, he's continued to do the things that you all acknowledged at that time. Obviously, to be at the barracks, you have to maintain an exceptional institutional record, as we know only 1% of the population can even go to the barracks, the prison population. He's facilitated NA and AA at the barracks, and that was kind of what he was trying to explain at the time, is that he's found that that going to a weekly program where he's able to connect with people and voice concerns or anything that he's going through as it relates to his sobriety is the method that works for him. As Captain Washington has said, he's maintained his regular work assignments, volunteers with upkeep. And so it shows you that he is not the same young man that committed the crime. And one of the things that I find about Bobby is that his insight doesn't just revolve around the crime itself. He understands that it's not just limited to the homicide, but also to the broader harm caused by the lifestyle he was living at the time of the offense, choosing to sell drugs and use drugs, and how destructive that had been to his community. He talked to you all about the fact that he understood the harm he caused, even at sentencing, right? He didn't get remorseful when parole became an option. The remorse had been there at the time when he heard the families. I know you early on, Mr. Freeman, asked about him being able to, is this a good thing for him to be able to, or why should he be given parole? How do we know that he's not a threat to the community? And outside of the record, we can look at what's been provided as far as his reentry plan. Obviously, he'd have all the services of the Louisiana Parole Project, but for Bobby particularly, his family has taught things in his particular community where Parole Project can hand off to. So having a family that's done reentry services within the jail system, and then the mobile crisis unit, which works kind of like our social work department. They provide the services, the NAAA services, the support services. They can do outpatient treatment if necessary. So he has a good handoff for his community. So today I can say obviously that Bobby hasn't just checked the boxes. He's proven the remorse. He's taken responsibility for his action. He served the additional time the board requested, and taken accountability for his crime and the problematic lifestyle that he had at the time. He has the community support that will also help him move forward, obvious employment opportunities, and a really realistic reentry plan that factors in like all those things that are looked at for public safety. And I believe that he is ready to done the work. And so we just ask that the board provide him with that parole with whatever condition y'all deem appropriate.
Okay, thank you, ma'am. Appreciate it. Okay, Bobby, let's get back to you. I note that you have had 7 DBs. Very good over 22 years. Your last one was in 2015. That was the Mojo, and at that time, the victim's mother is opposed. The DA, sheriff, and attorney general is opposed. My questions was mainly going to be to see that if you admitted that you fired the shot, you claim that right off the bat. You didn't try to lie about it. You acknowledge that y'all got in a fight and you're the one that fired the shots. Like I say, I have no questions. I'm gonna refer to my fellow board members.
I have no questions.
Right?
No, I don't have any questions.
Okay, I'm gonna move to an executive session.
I'll second.
Ms. Renat's second.
I concur.
All right, so we're gonna go into executive session at 9:31. We'll be right back. We just want to discuss confidential matters.
All right, we are in the Wayback Machine here, and we are into TCF overtime, so we're not going to wait around for this. I'm just going to bump us forward, and we'll get our answer here.
I think the panel is ready to vote. reside? Where's your house? Fine. Okay. All right. Mr. Williams is still, that's why we would discuss this so long. You're doing so great, and and time is the only thing we was back there, what's the right amount of time? You've been very honest. You've done everything we've asked you to do. So my vote today is going to be to grant to the parole project for 6 months. I know he has a house, Mr. Myers, but I want him at the parole project for 6 months. Okay, so he can adjust, and Ms. Williams, y'all can get together over there for y'all counseling and stuff. I'm sure they'll work with y'all. Okay, and that you 100% stay away from the victim or the family. Okay, I don't want you around wherever all this neighborhood where this happened. I think it was in Bunkie. I don't want you even in Bunkie. Okay, all right, that's my vote. Ms. Renatza?
I agree. I would ask that we could add special conditions once he gets settled to, and I think he indicated he wanted to do this, is to perform some community service work speaking to at-risk youth, and I'll let the parole officer determine, the number of hours that should be.
Okay, and I might add AA meetings to that also, but I know you're gonna attend. Okay, Mr. Prater?
Okay, I heard him a little over 2 years ago, and I was impressed then, but he hadn't served enough time, and for my benefit, I was hoping he wouldn't come back so quick. But he did, and in the meantime, in these 2 years, he did everything that he possibly could do in the way of his behavior, and the way of the courses that he's taken, in the way of the education and everything he's trying to do. So I think it would be very unfair if we didn't give him a shot. So I'm going to concur.
Thank you. Okay, you've been granted. Your vote was 3-0. Don't let us down, Bobby. We're putting a lot of faith in you, son.
I won't let you down. And if you need your grass cut, just give me a call.
No. Oh, no.
But thank you for the offer.
Thank y'all.
All right, ending the show off in a good way today. That's nice. Worth the overtime. Thank you all for joining me. I hope you all had fun. I know I did. So much fun that we'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific. If you're a channel member, join me a half an hour earlier for the pre-show. And, of course, tonight in the blind with Mike and Dan at 7 p.m. Eastern, 4 p.m. Pacific. Hang tight at the end of the stream. You'll be redirected over there so you can set yourself a reminder. Do go have yourselves a good day. Look forward to seeing you all again soon. Take care. God bless.